Medical Board to order. It's October 9th, 2019. I'd like to call for the roll.
Ms. Bowler.
Here.
Dr. Bradbury.
Here.
Ms. Laredo.
Here.
Dr. Nunez.
Here.
Ms. Prado.
Here.
Dr. Waterhouse.
Here.
Ms. Yanis is absent. Dr. Noland.
Here.
We have a quorum.
Great, thank you very much. We'll go ahead and start with introductions. Do we need to do the board? Yeah, we'll go ahead and ask for introductions from the public. If you'd like to start here in the first row. If you would like to, introduce yourself. If not, that's fine.
My name is Steve Hindy. I'm with an animal organization called Showing Animals Respect and Kindness.
Hi, I'm Janet Enoch, also with Showing Animals Respect and Kindness.
Thank you.
I'm Patty Rodriguez, Veterinary Medical Board. Karen Munoz, Budget Manager from Dca.
Vikram Dhaliwal, Budget Analyst from Dca.
Steve Ramirez with the ILWU.
Nancy Irwin, California Arbitration Association.
Grant Miller, CVMA.
Valerie Penster, for CDMA.
Sullivan, NBC. Mark Cushing with Animal Policy Group.
Bonnie Lee. Cindy Sager with Sacramento Valley Vet Tech Association.
Great, thank you and welcome. Do you want to do minutes or do you want to jump? Okay, I'd like to open it up for public comment at this time.
Do I sit here?
Yes.
Yes, please.
Good morning. My name is Steve Hindy. I am the founder and president of Illinois-based Showing Animals Respect and Kindness, or SHARK. This board was previously informed about a very seriously injured bucking horse who collapsed at the 2018 Folsom Rodeo. He couldn't move his hind legs. The rodeo vet suspected a hip fracture or spinal cord injury, but rodeo personnel did not allow the vet to properly assess the horse or treat the horse, other than to give drugs for the intense pain the horse was experiencing. The veterinarian was told that the injured horse was to be transported to stock contractor Cotton Rosser's ranch, which was over an hour away. There's no record of that Folsom horse receiving any follow-up care, and such a record is required by law. In fact, that injured, suffering horse, once removed, simply disappeared. Following the Folsom horse incident, Marilyn Jasper, Humane Society of the Sierra Foothills Board President, asked for answers from this board as to what happened. She also made a clear, well-founded appeal for new measures to relieve the suffering of rodeo animals. This board failed to respond to her inquiry or act on any of her suggestions. In 2013 and 2014, SHARK investigators attended the California Rodeo Salinas. They video documented 23 and 19 animal injuries, respectively, while the rodeo vet reported only 3 injuries and 1 injury, respectively. I filed a complaint both years with this board, and both complaints were discounted. SHARK subsequently filed a lawsuit against the rodeo. The discovery process gave us emails exposing collusion between a rodeo lobbyist and Joe Lee Walker, an investigator for this board. The collusion occurred during Ms. Walker's supposed investigation into my 2014 complaint about underreported injuries. I sent a letter advising this board of the collusion, and it predictably went nowhere. After this year's California Rodeo Salinas, the rodeo vet again underreported injuries. One case involved a bull with a bloody tongue following bull baiting, which was allowed at the end of each performance of the 4-day rodeo in spite of it being illegal. The video documentation of the bloody tongue is undeniable. The head of the local SPCA stated it was required by law that the bull receive treatment, but neither the bull's injury nor his supposed treatment was reported by the rodeo vet. A complaint for that unreported injury is pending with this board, but at this point, we have no faith. The veterinarian for the rodeo in Salinas is the younger brother of the president of the rodeo. The prior president was the veterinarian's father. The Salinas vet has also stated that he has stock in the Salinas rodeo. Can there be a clearer conflict of interest? Nevertheless, this board repeatedly takes the rodeo vet's word over video documentation. When rodeo animals limp or can't get up after a run or they bleed, it's because they're injured. They're not faking it. Unlike some people, animals can't be corrupted. Rodeo animals are forced to participate in violent exhibitions that put their very lives at risk. Doesn't society owe them humane treatment? Unlike human participants, they don't get to choose. In fact, this board's mission statement includes promises to protect animals and to promote professional standards. These are broken promises. This board has proven to be not a protector of rodeo animals, but rather a rubber stamp for rodeo animal abusers. The members of the California Veterinary Medical Board should either execute their duties faithfully or step aside for others who possess the integrity, ethics, and moral code required to do the job. It's time. Rodeo animals have suffered enough. Thank you.
Thank you for your comment. I do believe you're talking about an active case, so I think it's impossible for us to comment on that. I appreciate your historical cases, and I will have to do some research on those. I haven't been on the board long enough to know what you're talking about there. But I want you to know that we take breaking the law very seriously, and I would ask, were the local police also informed to file
The
criminal?
local police, the local SPCA, the local district
Okay,
attorney.
great.
Salinas is a rodeo town, and they can get away with anything.
So there's been no response from the local authorities either?
They have refused. They have said they will not do anything.
Well, I'm looking to legal counsel, but I think we do take this very seriously. We are very serious about protecting animals, and I assure you we will do our very best to deal with this in a fast manner. We've had trouble. We're backlogged in all of our cases. We're very, very behind because we lack the staff. So I understand your frustration, and I hear you. And I would just say we will do our very best to be as prompt as we can on this investigation. And
Well,
I thank you for.
Doctor. We will leave my card.
Okay, thank you. Yeah,
Rodeo, the veterinarian report for the Folsom horse.
okay.
And if you would like, we would be more than happy to submit video footage. It's already up on YouTube. It's been seen by many thousands of people. But the matter of the bull baiting in Salinas, they called it herding. But when the bulls are attacking the bulls and they're drawing blood and they're biting them in the face, that's not herding anymore.
Thank you. Yeah, I appreciate you bringing this to our attention, and we'll follow through. If you can give us a card, that would be great.
I appreciate your
Yeah, thank you.
response. Thank you.
Any other public comment? Would you like to?
The Salinas vet, or I'm sorry, the Salinas, the Monterey County District Attorney, who is refusing to do anything, is a longtime volunteer, says it right on her webpage, of the Salinas Rodeo.
Thank you.
Thank you. Any other public comment? Okay. Anyone else? Thank you very much.
Thank you.
In the interest of accommodating our DCA colleagues, we are going to move down to agenda item number 9, and would like to invite them up to the podium. Thank you. And while they're getting settled, if you have a card you want to bring to me.
I just want to say thank you for accommodating us and pushing us forward. It was Yeah, no? Okay, I just wanted to thank you for accommodating us and getting us ahead on that on the schedule. That was great.
And if you can identify yourselves as you speak
My
to
name
that,
is
thank you.
Karen Munoz. I'm the
Thank you.
DCA budget manager.
Sorry, one sec, can I look at your microphone?
Better. Okay, my name is Karen Munoz. I'm one of the budget managers for DCA.
And my name is Bikram Dhaliwal. I'm the budget analyst from DCA. So to get started, we're here today to talk about the current state of the fund, as well as discuss the proposed fee increases. As you can see from the first fund condition statement, the current state of the fund for Veterinary Medical Board is not doing so well because of two primary reasons. One being approximately $150,000 to $200,000 in decreased revenue from the elimination of the RVT state exam. The other being an increase in the AG rate. And Veterinary Medical Board does typically spend up to the AG budget, so the increase is definitely going to make an impact. And as you can see, I don't know if you guys have the fund condition out in front of you, but on the bottom right, in fiscal year 2020, 2021, it shows that the fund is going to be in negative 1.2 months in reserve, and even worse moving forward, meaning that it's insolvent. And to address those issues, there have been proposed fee increases that we believe should be implemented. And with that being said, those apply to the delinquent fees, the renewal fees, and other regulatory licensing and permit fees. And essentially, we want to, the proposal is to increase all those fees to the statutory max to offset the AG rate increase, as well as the decrease in revenue from the RVT state exam being removed. And then with that proposal and that scenario, you can see that the fund condition is looking a lot healthier in terms of being in 2.5 months in reserve in fiscal year 2020, 2021, and even 4.4 the year after. And that definitely gives the fund some wiggle room and opportunity to seek the additional resources that were even mentioned earlier in terms of enforcement to reduce that backlog.
Thank you for being here. Can I ask you a question?
Of course.
Would you mind clarifying the Attorney General fee increase and what kind of impact that has on us specifically in numbers?
Yeah, of course. In terms of like the actual increases, the attorney services went from $170 to $220 an hour, which is roughly a 30% increase. And the paralegal services went from $120 to $205, which is a 71% increase. So as you can tell, they're pretty massive increases. And as I mentioned earlier, VetMed does historically expend up to at least the appropriated amount for AG expenses, and in some cases even needs an augmentation just because there's so much workload. So yeah.
Okay, thank you. Thank you.
I was wondering, I see that there's increases in everything except for the veterinary premise fees, and pretty significant increases in the RVT licensing, and I feel like of the people that we oversee and collect fees from, they are the most impacted financially and don't really have the means to potentially cover these fees, whereas businesses and veterinary premises probably do and also have that as part of their like write-offs and things like that. So a reason why we chose to go for the licensing.
I believe just
Yeah, so it's because it's already at a statutory cap, and so that's why we can't do that through regulation, but it's an issue that we can address through sunset to raise all of the statutory caps up, and then we would be able to collect more fees that way.
Okay, thank you.
Any other questions? Thank you. Anything else?
Is there anything else you'd like to?
Yeah, we don't have anything at this time.
Okay.
At the next board meeting, we can present a projection for the board
Okay.
and where they're standing.
Okay.
So I do have a question. And so when could these fees be effective, potentially?
I believe the board is going to be seeking an emergency fee increase to these, so they could potentially take effect. I mean, they're hoping to be before July 1st, but it could potentially take effect in the next couple months.
Okay. And so the fund condition that we have in our binder here, so that reflects the fee increase?
So you have two fund conditions. The last one would reflects the fee
Reflects it,
increase,
okay.
yes.
Okay, thank you.
Any other questions? Yes.
Is this something that we're taking action on? Was this just an FYI, further discussion?
So we'll need a motion if the board agrees to pursue emergency fee regulations. So we would need a motion to pursue the emergency fee regulation, and then also a motion to proceed with a regular rulemaking process after the emergency fee regs.
Okay, I just want to make sure, because I have a big problem with this, and I don't want to push it forward if that's without discussing it, so thank you.
Any other comments? I guess I have one, and that is I think we really feel very good about our decision to eliminate the California-based RVT test. I thought that was a really good decision from the standpoint of consumer protection as well as helping our registered veterinary technicians in the state. So I guess I want to go on record that I thought that was a good choice, and I think, but I do agree with Dr. Bradbury about, I don't think we want to come back around and take the money back from them via increased licensing if we can help it, so that's my comment.
Have we
Dr. Nunez.
considered a bake sale?
Are you volunteering, Dr. Bradbury?
Can I,
I'm sorry,
Yes,
actually,
we've got-
the cameras are interfering with the webcast. He can't see, so if you don't mind.
yeah, why are those cameras in here?
Perfect. Yeah,
Thank you.
thank you, thank you. I think Dr. Bradbury first, and then we'll move down.
So I want to understand, are the fees for veterinarians at their statutory limit in this set, like with this number? And so that's, I guess, my first question.
Yeah, so in the document provided yesterday, the original one that was in the packet didn't show you what it was versus what it's going to be. The new document that was provided does show that.
Yep.
It's raising all fees to their statutory cap.
Okay, because it seems odd that the fee for a veterinarian is the same as an RVT. And I don't know how we're not going to have help. That's not going to help the public. I don't know how we're going to be able to sustain the.
Wait a
This
minute.
one's 500.
No, I know, but like the eligibility review fee, it's just, they've gone up almost double versus, or more versus what, but if we can't go up anymore for veterinarians, that, I understand why, like.
Well, I did have a question, and part of it was on the proposed increases that we received yesterday, Jessica. In the application eligibility review fee for all exams, is that also include when individual students are taking the NAVLE? There's an application, they have to name their jurisdiction in the NAVLE. Is there a fee? I know there's a fee. So this has nothing to do with that. This is
No.
just a review of the application to file for a license.
Correct.
Okay, thank you.
I believe that RVT is in such shortage in California that I certainly pay for my RVTs. I pay for the license, and I think that's true of most practices in the state, that the practice pays for the RVT license.
You do too.
Yeah, I do.
Okay. Jennifer?
Say, We had this discussion before, as the doctor sitting up here, you guys are all amazing, but it's not the standard for RVT licenses to be covered, and I'll tell you right now, mine isn't covered. I have to pay for it myself, so I got a lump in my throat when I saw this. And I'm not complaining, I'm very fortunate with my salary, but when you compare my salary to that of the doctor that I work for, they are not comparable. So the same fees, I think we all agree, are not reasonable, but in the area where I reside, it is not the standard for veterinary hospitals to pay for their RVTs. So this is not going to be well received by the veterinary community.
They're already at their max.
Any other comments? I guess I feel pretty strongly the same. I would rather see us
Where is that on here?
try to, through Sunset Review, change the cap on premise permits and also on veterinarians and try to really modulate what we're doing to the registered veterinary technicians. I just think there must be a better way.
So if the, from what I'm hearing from the members, that you would rather not increase the fees for the RVTs at this time? And we can,
Yeah, or maybe
or add
instead of going to 350, go to 200. And instead of going to 350, go to 200. So I mean, I could see us raising them slightly moderately, but I think it's really not in the best interest of California and the public to raise them to the cap.
So have we done projections so that if we did, say, make the RVTs at $200, what would that do to our fund condition?
I think right now, we've only worked one scenario right now to raise all fees to statutory cap. I could work with Jessica to give her a couple different other scenarios where we can work with the numbers and raise certain fees as the board likes.
would it be possible for you to do that today? We have to do something with our fund. So I would rather if the board is able to see projections and they can get a motion so we can start the emergency rulemaking, that's my goal, because we need the funds now. So,
Yeah, we have the numbers to work with. We can just plug in a couple different numbers for the RVT.
okay,
I just need to know from you, like, what those numbers will be.
Right.
So if you can forward those over to Vikram, he can work those numbers for you today and send them over.
so what are you guys comfortable with?
And could we also include one where we don't change the numbers on the RVT? We just leave it where it is so we can see our options?
So that would be the first option, is to increase all the fees on the top, and then for the RVTs, leave them the same. And then, Dr. Nunez, do you have a?
Yeah, is the second option to do C and D to 200 under the RVTs, the initial registration and the renewal from 160 to 200?
That would be a suggestion, Kathy? You have your hand.
Yeah, I was going to, well, this was more of a modified thing to make the initial registration a little bit higher and then the renewal a little bit lower. If that makes sense, just maybe 250 for the initial and 200 for the biannual, the renewal.
So 250 for C is what you're proposing? Oh, 250 for
For,
A.
oh,
That's not what she said.
I
She
was
said
saying
C
the
and D.
initial registration fee,
That's
which
it,
is
that's
C, I
C.
guess.
What about A?
I'm still confused about
So
what
just so you know, when it comes to revenue, we get most of our revenue from renewals. So
Okay,
that's where the most
okay, the
influence would
revenue,
be.
okay, so the bigger hit would be on the renewal then, so maybe reverse that.
But the renewal,
open to
they're
it.
doing that every 2 years, so over a
Correct.
lifetime, it's still going to hurt them.
How do you feel about increasing the biennial renewal fee to 200?
I'm still against it.
Okay, we have one no. Anyone else want to? It's just to do
It's just
a
to get
workup, you know.
scenarios.
I think we should look at it.
I think we
At 200, okay.
Yeah.
So that'll be our second scenario, is to raise that to, and what do you want to do with A, B, and C?
250.
Okay, we have a motion for 250 for A.
And to clarify, there's no motion now, it's just.
I
so-
know, just
Yeah,
a
right, we're just-
suggestion. I'm sorry, a
yeah.
suggestion. How about 200,
I would say 200 for A and 250 for the initial and 200 for the renewal. Is that what you were saying, Kathy?
Well, kind of, but I may be wrong on the, I may be wrong on the income. I mean, the bottom line is, we don't want to do it, but our fund obviously
Right.
needs it, and there's no other, we have no other funding sources other than these, so I'm trying to figure out what way we'll.
So,
But if
so
we
let
don't
me
have people
suggest
renew-
this and
like-
see.
Right.
Then we don't get anything.
Let me suggest this and see what you think. So going to 200 on A, leaving B at 200, going to 250 on C, 200 on D, and leaving E at 50.
I think that seems
Is that, okay, so
like a
did
good
you catch
scenario.
that?
I'm just a little confused with what A, B, C, and D are.
I'm sorry, this is, the code
Sorry.
2071.
paper we do.
renewal, I'm
I
assuming.
can email it to you guys.
Yeah,
So
okay.
we're looking at two scenarios. One of them keeping the proposed, well, both of them, we're keeping the proposed increases for 2070. Thank you, Nancy.
Thank you, Nancy.
And then 2071, we're going to, one scenario with not increasing those fees at all. And then the second scenario, changing A to 200, C to 250, and D to 200.
And leaving E at $50.
And would it be possible to also have what the fees are now in comparison, just so that it's all in one
that
document?
what
when you
Yeah,
have it?
that's what, you have it next. Yeah.
Comment?
My
Yes.
only objection to that is that application eligibility renewal, if an RVT doesn't pass an exam and they want to retake it, they're paying that fee again, right? Every time they want to take this test.
Are they?
The VT&E?
Or the application. Application, okay, never mind.
It does, I don't think that's true because there's no test.
Right.
Right.
Any other?
I do. I just want to give a little bit of background on what might be perceived as my hostility on this subject. Way back, I've been on the board 5 years now, and way back, we were discussing the option of decreasing fees for RVTs because it was such a hardship. And in the midst of all of that, we had our budget crisis and we did have to increase. I was against it, but I did go with it because we had no other option. I'm not going with it again. So
And
that's
my
where I am.
response would be, we did decrease them by eliminating one of the tests, which was, I think, a significant decrease. And what we're trying not to do is, undo that, right?
Right.
Any other comments? Yes, Kathy?
Long-term, another option, of course, is, but it wouldn't affect us for a while, is looking at raising the caps on
Well,
some of these long-term licenses.
Actually, I would recommend that we address that now and do that through our sunset bill.
But I mean, I'd say, that's what I'm saying, we would do that, but it's not going to go into effect for a while, right? Potentially.
Right, so potentially it'd be a
And
year.
Getting the income wouldn't happen
Yeah.
for a year or two.
For a year, yeah.
Yeah, but yes, that's something, obviously, we necessarily need to look at these.
Yeah.
And where we can change, keep the RVT where it is and raise a veterinarian. Okay.
Great. Any other comments? Yes.
Just a final comment that I don't think that veterinarians or RVTs, or maybe even the general public even understands that we are fully funded by, that this is all we are funded by. So I just want to make that comment public so that it is clear, because I didn't realize that until I became a member of the board. And when I've told people that, they're pretty shocked. And so it is unfortunate, but that's where we're at, where we have to generate our income in order to pay for the extra staff we need for all of the complaints that we need to address.
Okay, I think we hopefully gave you some ideas, and thank you very much for accommodating our plans or our questions. Thank you for coming, and we appreciate it.
Thank you.
And Jessica will
Thank
be
you.
in touch, I
Yeah.
think. Thank you very much.
No, not yet, because I'm hoping to present numbers to you later this afternoon, so we can get a vote at that time. And we're going to do minutes first.
Okay, sorry. We're going to go ahead and move on to agenda item number 4, which is review and approval of the board meeting minutes. Oh, I'm sorry. We were going to get the new figures, but we're happy to have public
Yeah.
comment. We're actually tabling it till they give us 2 cost scenarios.
Right.
But if you would like to publicly comment now, that's great.
Dick Sullivan, not representing MDC today, or right now. My comment is, why isn't there some pushback to the Attorney General's office on these fee increases? I don't particularly like attorneys in the room, but 2 of them were sitting behind me and gave me the information that this is way above the standard that's in the public realm. So, yes, we do need them, but accepting every raise that they pass on down to us, I don't think is good fiduciary responsibility. This is, there's 2 sides to every ledger, and one is reducing fees and not just passing them on to the licensees. Thank you.
So I can tell you, I could not agree more. And there has been pushback from DCA, the boards, and the legislature. No one's happy about the fee increases, and this is something that everybody has been dealing with right now.
But I think to be responsible ourselves, we have to, move forward in case nothing happens.
Other than being unhappy, we don't have any other choice. We don't have the ability to do anything
None of
about
the
it.
boards,
Is that correct? We don't have a choice.
we have to use them.
Nancy Ehrlich, Carpta. You've been bringing up the elimination of the RVT exam as a loss of income, but I was under the impression that the exam costs were supposed to be paid for by the fees for the exam, and that by eliminating the exam, you've also eliminated all the costs associated with the exam. So I didn't think it was a profit-making enterprise. I'm surprised to hear that you're saying that you've lost income as a result of eliminating the exam, number 1. And number 2, I think you have to consider that we are already here that RVT candidates are not applying for the exam because with all the debts that they have from going to RVT school, they find that they can't afford the fees for applying. And by adding more fees, you're going to find that you're going to be decreasing the number of RVT candidates. And so I'm not sure that it's going to end up helping your budget when you end up eliminating RVTs because of fees.
Dick Sullivan again. I want to qualify, my comment was regarding the paralegal fee
Yeah, I was-
increases, not the overall, not the attorneys necessarily.
Thank you. Bonnie?
Hi, Bonnie Lutz. Just to add to what Dr. Sullivan is saying, to put it in perspective, one of my competitors only gets $170 for attorney's fees. And I don't know, I think the paralegal is paid somewhere around $90. My paralegal gets $150 an hour only on private pay cases where we're competitive with the, semi-big firms. Big firms, paralegals only get, I think, maximum $180 an hour, $205 an hour for a paralegal, especially when the attorneys are only getting $220, is really outrageous. Now, $220, frankly, is sort of reasonable. I mean, you could still push back, but that's semi-reasonable for an attorney. But $205 for a paralegal, as much as I respect paralegals, is outrageous, even if you look at the big firms.
Would there be any way that you that are making public comment could contact your legislators? We need help with this. We really do.
Sure.
Because we agree 100%, but we don't have, the power as one board. We need to unite on this.
I'd be happy to. Thank you.
Okay, thank you. Jennifer?
I have a question. I'm embarrassed to say I really don't know how the process works, and I'm hearing a lot of, this is how it is, everybody's unhappy, and it seems that everybody's accepting that that's just the process, we have to accept it. What, other than calling our legislators, what other resources do we have to push back? What could we do?
So I can talk with DCA and determine, I don't know overall what their overall plan is, but I do know that everyone is in the same boat. And I can get more information and report back to you guys.
Okay, so we should go on strike? I mean, do we picket?
I don't recommend that, but I'll get back to you.
Yes.
Cindy Savely, RVT. I happen to serve on an advisory committee for a local college that has an RVT program. And I would say over the past, well, I've been on the board or the advisory committee for 5 years, and I have heard from students who are graduating how much of a challenge it is to pay the cost to even apply to take the exam. So the students that are just starting off in their technician RVT profession are the most challenged when it comes to money. I am also on the board for the Sacramento Valley Vet Tech Association, and our members, we have about 100, and they vary from starting out in their profession to members who have been working for 15, 20, 25 years. And I too would feel that they would have a hardship in paying the renewal fees. So anyway, I just, from those two extremes, the newbies starting off to the members that we have in our association that have been working as RVTs for a while, it would be, both increases would be a hardship. Thank you.
Thank you.
Bonnie Lutz, I have one other comment that I just thought of. When you all file an accusation against a veterinarian, and the veterinarian then goes to a hearing, the veterinarian has to pay the one, we call them 125 costs. It's Business and Professions Code, Section 125. So the veterinarian has to pay all of your costs, everything that you've paid the DAG, Deputy Attorney General, from the time that the investigation began up to the first day of the hearing. And the costs also include the DOI investigation, but I'm just talking about the DAG costs. So this increase in the DAG fees for the attorneys and the paralegals is going to raise that cost dramatically. Now, I know that you don't have to worry about whether it increases the cost for the veterinarians, but there's a case called Zuckerman under which we are entitled to ask for a drastic reduction in the costs because the veterinarian has the ability to go to a hearing. I mean, he has the right to go to a hearing and defend himself and not just roll over and take probation. So, I mean, I can see other far-reaching effects of this increase in the cost, especially with the paralegals, because frankly, one of my arguments with Zuckerman will be, when we do go to a hearing, will be that this cost that we're paying a paralegal is outrageous and unreasonable. And I do think that we will persevere and get a reduction in the cost, which will mean that you guys will end up with those costs. So it's really going to have far-reaching effects, I
Right.
think.
Can I ask for clarification? So the veterinarian, if it does go to a trial, they don't have to pay those fees if they are acquitted, is that right?
Well, there's no acquitting.
So
The frank answer is that in 20 years, I've had 2 dismissed at the hearing.
Okay.
Usually, there's enough in the accusation that the administrative law judge at least finds enough cause for some of the causes for discipline. So they
Okay.
find sufficient evidence. So our argument then is, say you have 10 causes for discipline, the DAG is able to prove 5. We argue Zuckerman costs that they should be cut in half because you weren't successful on 5 of
Got
them.
it.
You're only successful on the other 5.
Got
So,
it.
but I think an additional argument that I will make will be that the costs are not only, that they're outrageous because nobody pays a paralegal $205 an hour. I just think it's going to have far-reaching
Sure. No, I
effects for you
appreciate
guys
that.
and for the
Yeah.
veterinarians.
Yeah, thank you for cheering us up on that one.
And I know that staff is dismissive about us not being able to do anything with the AG's office, but that is an
Yeah.
excellent point, that is really going to destroy us.
Yeah, and I did want to clarify, we're not trying to be dismissive, that we're not going to do anything. I think that we need to unite as all boards that are impacted and the legislature.
And just another note, obviously, according to the letter, they worked with the Department of Finance to create these costs and disseminate them, but I would assume these conversations are going through every single board at DCA and to the highest levels, and it's up to I actually think that the DCA should be working diligently, someone should, with the governor's office to address these, because it is going to come back and haunt all the boards. And it's going to be, and it must be across the board in all agencies as well. The AG's office represents the state in lots of levels, and that they're increasing these prices, it's affecting everyone. So.
Okay, any other public comment? Okay, thank you very much. Now we'll go ahead and move on to item number 4 on the agenda, review and approval of board meeting minutes. We'll start with item A, which is the July 17th and 18th, 2019 minutes. Yes.
I just had a comment on page 3, under item number 6, in the first sentence. It says, regarding the approval of guidelines for veterinarian cannabis discussion animal patients. And I just don't know that that makes sense. I don't know what that means.
Rob, it's number 6.
Under review discussion.
We actually asked the MDC to come up with some guidelines for veterinarians to be able to discuss cannabis with their clients. So that's what that's referring to. It could be the wording.
It's just,
Okay, well, yeah, I'm
it
not
doesn't make sense.
Not an English major. Yes, Tara.
Yeah, I think that should be corrected. We could do that quickly. If you, on that second line where it says veterinarian cannabis, let's strike cannabis. And then on the next line, after discussion, insert of cannabis treatment in. So it would read, regarding the approval of guidelines for veterinarian discussion of cannabis treatment in animal patients.
Perfect, thank you.
Is treatment the right word for that? I thought it was just discussion of cannabis, not necessarily treatment, but
I'm looking at item 6.
I think we can take that treatment.
So we can do discussion of cannabis within the veterinarian client-patient
There we go.
relationship.
yeah, that, I was going to try to.
Okay. We can make that change.
Okay. Good catch. Anything else?
It looks like we might be on the, no. On page 6, under L, it says if the board has an opposed if amended stance. I thought it was opposed if not amended was what we were talking about, but again, I don't know. The board discussed submitting language to the author's office,
It should say unless amended.
Yeah, unless amended. Good catch.
and not if amended. Because that sounds like we were going to oppose it if they amended it, but anyway, so opposed unless amended.
We can make that change.
Thanks.
Good, thank you. Cheryl?
I read right over it.
Oh, okay. Go ahead.
On 4, under, second paragraph, under 9.
Can you put your microphone on, please?
Oh, sorry. Okay. Item number 9, page 4, second paragraph. And so Mr. Suevos Romero advised that his office, what office? Who was he from?
He's with the Division of Legislative Affairs of DCA.
I don't think it doesn't say that anywhere.
We can add that.
Was brought into the conversation by the governor's office. And so, the next sentence says that he advised us that this regulatory change is not imminent, but didn't actually we tell him? didn't we tell him that this regulatory change is not imminent and there will be ample time for public comment?
I can go back to check to see if he said that as well, because I think he knows that it's also not imminent, so I don't know if he said it
Okay.
and we
'Cause I
said
thought
it.
we told him.
I think we both knew that it's not, but I can,
Check
we
on
can
it.
check that.
Okay. Jennifer?
You guys are going to think I'm being cranky today, so I apologize in advance. On page 9, item 16, future agenda items, when it says the board discussed changing the board meetings, I just wanted to point out it was less of a discussion and more, I felt it was more of an announcement, had already been discussed amongst, outside of the meeting. And the only reason I bring it up is because later in our board packet, on our sunset, we have a list of all of the board members and the meetings that they've missed. And some of the meetings I missed were because we deviated from the scheduling. We changed the week that it normally is because someone couldn't attend, and then changing the days because a lot of us do schedule our schedules quite far in advance. So I just wanted to point out, I do like that it says discussed, but there was no vote. Some of the members had already left, so just kind of going on record that I felt it was more of an announcement. The board, the entire board didn't really get a chance to have input on that.
And I'll support that. It wasn't discussed, it was just announced.
Because you left.
So are you asking to change it from discussed to announced?
Maybe.
Yes.
Or are you asking that we further discuss it?
No. I would just like to say that it was announced.
Okay.
I'll second that.
Anything else with this? Anything else on this minutes? Okay. Can I hear a motion? Or would you like to go to the second meetings and do it all together? Do you want to, can you motion to accept these?
As amended.
Adopt
As
with
amended?
amendments?
Yes.
So motion.
Okay, so motioned by Dr. Waterhouse.
A second.
Waterbury, as we know it. Okay. A second by Kathy Bowler. Call for the vote.
Ms. Bowler?
Aye.
Dr. Bradbury?
Yes.
Ms. Laredo?
Yes.
Dr. Nunez?
Yes.
Ms. Prado?
Yes.
Dr. Waterhouse?
Yes.
Dr. Noland?
Yes.
Motion carries.
Okay, moving to Section B, the notes for the teleconference that was held Thursday, September 12th. Any corrections?
The
Yes.
4-hour telephone call.
4
That was
hour
amazing.
telephone call.
Yeah, with my power out. It was fun.
Power out.
Power out. Okay, can I entertain a motion from someone? Or are there comments?
Anybody, public comment?
I would move to approve.
Public comment on
Do you need
minutes?
to charge? You're gonna unplug mine.
Oh. Any public comment on the minutes? Okay, I don't have a motion yet.
I move to approve.
Okay, motion.
I second.
Okay, seconded. Any comments? Okay, call for the vote.
Ms. Bowler?
I'm sorry. For a second, I was just still reading my note. I did have a note on here, I'm just
Oh.
trying to, but it's probably. Aye.
Dr. Bradbury?
Yes.
Ms. Laredo?
Yes.
Dr. Nunez?
Yes.
Ms. Prado?
Yes.
Dr. Waterhouse?
Yes.
Dr. Noland?
Yes.
Motion carries.
Did you say there was someone from DCA here?
No, but.
Okay.
um,
We're going to ask Jessica Sieverman to comment on number 5.
Yeah, so
Yes.
number 5, unfortunately, there wasn't anyone available to present the update from DCA today. However, I did provide their written update from the Deputy Director of Board Bureau Relations, Chris Castillo, and I also provided it for public comment, or for the public on the table. One thing I do want to announce that's not in there, that the governor announced yesterday, is we have a new Director of Dca. And I've got to tell you, it's a good day for DCA. We have the best director we could possibly have. I have been at DCA for over 11 years now. She's our 6th director since I've been here. But she has so much knowledge, and she knows all the issues. She will hit the ground running. I could not be more excited for DCA. This is a good day. So, and I have asked her, oh, I'm sorry, it's
Explain
Kimberly
who she is.
Kirchmeier. She's the, Kimberly Kirchmeier. She was the executive director of Medical Board. She also had some time several years ago being in the executive office in board bureau relations, and then she was at Medical Board before that. So she has extensive experience with all the issues. And I have asked her to come, I told her I know it's short notice, but I asked her to come and introduce herself to the board. So I'm hoping this afternoon she'll be able to come and introduce herself. But this is such a good appointment.
Great.
So,
Excellent.
any questions?
Any questions? Oh, yes.
Do we know what her opinion is on the AG fees?
I bet we do.
We do.
It's probably similar.
But feel free to ask her.
Yeah. Kathy?
Yeah, and I know they're not here to ask, but one of the things I found interesting in this little summary is the DCA We're Listening
Yeah.
brochure type of thing or whatever. And I was really interested in what their distribution method was going to be about that, and whether it was going to go to all legislative offices, all offices, et cetera, because I think it would be nice if consumers understood a lot more about how the DCA work, how all the boards work, how to file complaints and whatnot. And it would be nice for DCA to take the lead rather than coming out of individual boards' budgets. So I was just going to say, so what's the plan on distribution of
Yeah,
that?
I can find that out and get back to you.
Okay. And on the Future Leadership Development Program, they don't list who the individuals were that were appointed or whatever. Is that something, I'm not even quite sure what that program is, but it says 8 individuals were selected.
Yeah. So I can tell you, I'm on the steering committee for the Future Leadership Development.
Oh.
And so we're very much involved in growing future leaders, and the whole idea is to groom the next EO and bureau chief and executive level leader in DCA. I don't know if it's highly publicized who the individuals are, but I can tell you it's a pretty competitive process that we go through to make sure that they are committed to DCA, what their goals are, and what we can do to help them reach those goals. The whole idea is to be able to recruit and retain our next level leaders.
It's like, how many people would be in that cohort?
It depends. We don't want to set a number to each one. We want to go by the quality of the candidates, not necessarily the quantity.
Ballpark.
So,
Is 2 or is this 20?
so there's 8 in this one. I believe there were 7 last time. It just depends, and then they all work on a project together that will help DCA as a whole.
So have you been on this? Have you participated in it yourself?
No, I've been on the steering committee for 2 years now to identify the individuals.
Any comments? Okay. Okay, we'll move on to number 6, the review, discussion, and possible action on the MDC report. Dr. Pollard?
Good morning, Jeff Pollard. We had a very friendly and joyous, and everybody agreed on everything yesterday. Wait, that was my dream last night. 3 big topics in your packet. In our packet, the MDC packet, item agenda number 5 was the beginning of the discussion on corporate practice of veterinary medicine, specifically concerns about undue influence on veterinarians by non-veterinary owners. For logistics, Jessica and staff arranged for call-ins from anonymous callers. 4 people called in, 2 of whom identified themselves, so it wasn't completely anonymous. And there were 2 other public members that aren't usually at our meetings. They were 2 third-year UC Davis students. And all of these people had very valuable input to the questions that are being discussed. I thought the students were incredibly articulate and very helpful to, I think, the committee and will be to you. Additionally, one of the Veterinary Medical Board consultants weighed in, and without itemizing each of the concerns they had with their particular employment situation, I would say that we have some work to do. We want to CVMA's request, I think appropriately, itemize more detailed what specific concerns we have with the veterinarians in their situations. And then it becomes a more complicated topic when you talk about the contracts that veterinarians have with their corporate employers. And I think one of the seminal comments on the committee was by Dr. Sullivan, who pointed out that however far and deep we go into this topic, we should broaden the concern with not just non-DVM owners, because many of these issues apply in many veterinary practice, whoever is the overlord. Some public comment was very helpful too. The CVMA weighed in, and as I mentioned, I think one of our next points to consider at the next meeting will be an item-by-item detail of what the issues are. You may recall this was discussed not last meeting, but in April for the first time at the Riverside meeting, and there was a survey. It was done on rather short notice before the meeting. I think they had about a week's notice. That was referenced yesterday. I think some of these callers were contacted as a result of their survey responses. So I think I'll leave it at that and just conclude that, one other item. It was noted that there's a lot of legalese involved in this topic, that the committee members are really short of legal counsel, not really very qualified to delve too deep into. Ms. Bonnie Lutz was very helpful in going more or less line by line with some of the items, and I think that will help us narrow down what change we come to, whatever that may be. And I just conclude by saying we, serve at your pleasure, and we'll do whatever next step. But my view is that the subcommittee's work has been excellent. It's the public member, Stuart Ekman, and Vice Chair Christy Pawlowski. I think they're doing a great job. It's a big piece of the apple to bite, but I don't think we're done.
Dr. Nunez?
Could you provide a little bit more insight on that specific issue of who's allowed to own a practice and therefore who exactly is disciplined when there's discipline needed? And how that applies to this whole regulatory issues and legislative issues of corporate ownership?
I'm going to defer to legal counsel, and that it boils down to those 2 words, premise and practice. And as you know, the premise permit has a managing licensee named, and that topic came up specifically. And if it's corporate-owned, I'm not clear, I don't know the process as well, but it's not clear to me who's on that premise permit. And then when discipline has to happen, who's it addressed to?
So part of what we're going to address and discuss later in the Sunset Review Report is the premises ownership issue. So we're hopefully going to be seeking some clarification from the legislature as to premises ownership, premises location versus brick and mortar building. But as far as the corporate practice issue goes, there's no limitation of a non-professional corporation owning a registration or being the registered holder of the premises. I mean, we've got, a bit of a funky statute there in that all locations where veterinary medicine is being practiced have to be registered. So a non-professional corporation can register a premises where veterinary medicine is being practiced. The corporate practice issue is really about whether or not the non-professional corporation is exerting control or influence into the practice of veterinary medicine. A side issue is the registration information and making sure that the board has knowledge of who's involved with the premises. Other issues involve unlicensed practice and whether or not the board can discipline the premises registration holder like a corporation, whether that be professional or non-professional corporation, for influencing a licensee's practice. So that's one of the things that I've been tasked with resolving, or at least bringing some language back to the MDC to address unlicensed practice issues of the premises registration holder. The discussion about corporate practice is starting, we're really starting to dig deep and understand how it influences many areas, and how perhaps it may not need just legislation under the Professional Corporations chapter in the Practice Act, but also clarification in other statutes. So it's clear to licensees, registrants, board staff, consumers, who can do what and what is being enforced.
I mean, I do understand that there is there's a distinction between the two issues, but my question is, should this be incorporated under the umbrella of the corporate practice, which is a task that we've assigned to the MDC, or do you feel that we need to assign a separate task and therefore a separate subcommittee be made to address ownership and permit issues?
Well, I think that's going to be up to you, but I would recommend that you review the proposal for sunset review with respect to premises registrations.
I mean, you made a good point yesterday about the definition of a practice. Is that referring to the business of the veterinary hospital, or is it referring to the services provided by the veterinary hospital? And I think there's a distinction between the two.
So the legislative proposal that you'll be reviewing later in the Sunset Review Report attempts to make the distinction between the brick and mortar, the real estate, and the location of where the veterinary medicine is being practiced. I think that clarification would go a long way. But whether or not the board wants to try to define what the business is, that should be, I think, discussed first here, because I don't necessarily agree that that's particularly related to corporate practice, the corporate practice issues. But yeah, if you determine through discussion, potentially under the Sunset Review Report item, that ownership of the business versus the location needs to be discussed further. You could delegate that to the MDC for further review.
Because it could be said that this feared undue influence by corporate owners is being applied to the business of the practice and not necessarily the services provided by the practice. If you're talking about, I mean, there was a point about budgets being changed because revenue wasn't met yesterday. But as I understand P&Ls, you set your budget based on whatever revenue you've received. So that, in my opinion, is having an influence on the business of the practice, not necessarily the services that are provided by the practice. Does that make sense?
I think it's hard to.
Yeah, and I think on some level, we need to be conservative as to what we're doing. And all we're really, I think, trying to do is draw a line as to where the corporation ends and the licensee begins. And to the extent that there are financial concerns with respect to how the business is run, I don't know that this board really wants to start dictating how a business is run. On the other hand, if we're talking about whether or not a licensee is going to get paid and how much for the services that they're pushing to clients based upon the corporation's requirements, I think that's something that we're looking at.
And the board definitely should tread lightly when you talk about applying this universally, not just to corporate practices, but to all practices. We'd be really stepping into an area that we really shouldn't be.
I think these are issues that will probably be further discussed with the MDC, especially with the development of a list of, items that need to be fleshed out.
Other comments?
Yeah, I had a question, and I unfortunately could not be there yesterday. It seems to me at the MDC, the last meeting, there was some discussion of extending, sort of reinitiating that survey to try and get some more data in.
Yeah,
That was,
I can speak to that. I asked that question of Christy Pawlowski, and she indicated the survey was still open, but whatever that original number was, 500 and 574 stick in my mind. She said that there weren't that many more replies.
okay, it's all about outreach on that kind of thing, too.
But also to clarify too, in that survey, there was a question of whether or not those people would like to provide more information. And so the subcommittee went through those surveys, identified those people who would like to provide more information, and did follow-up questions with those individuals.
And has that data been aggregated, and was that presented yesterday?
Yeah, so the responses that we got were provided to the committee, and there were a lot of people who were concerned with coming forward, want to know what protections that they had. There were 4 that ended up calling in, and 2 didn't want to identify themselves. There were more prior to the meeting who had intended on calling in, and then for whatever reason, the day of the meeting, they weren't able to.
Thank you.
And I'm sorry, going back to this premise permit, there was a comment made by Valerie Fenstermaker from the CVMA about how she's received numerous calls from widowers that have inherited practices and have been told that they have to sell their practices because they're not veterinarians. And nowhere in the Practice Act could you find that a corporate can't own, or a corporation can't own a practice, so you have to be a veterinarian to own a practice?
So perhaps Val can clarify, but I can't speak to what was said in the past. I can tell you that's not our interpretation now. We wouldn't be saying that. But I don't know if Val's willing to clarify.
That's not quite what I said. No, I said many, many years ago, there was a situation, only a veterinarian could own a practice. So many years ago, there was a situation where usually it was a male veterinarian would pass away and the spouse was told that they had to sell the practice. And at that time, there was a change toward allowing, I don't know if the statute was changed, but it became understood that anybody could own a practice so that you didn't have to lose your livelihood because your spouse passed away. The number of calls we get now are from attorneys who are asking, can a non-veterinarian own a practice because it's not clear in the statute. So that's what I brought up yesterday, was providing some clarity as to who can legally own a veterinary practice, because my understanding over the years is that it's silent. So
So the widowers are no longer calling, but the lawyers are, because the issue
oh,
is
yeah,
still
that
not
was
clear.
a long time ago, but that's the concern now, is if something's going to be changed, is to be clear who can own a veterinary practice, and it all seems to be tied into the Professional Corporations Code, which I know is quite complex. So those were my comments on that.
Yeah, I had actually a similar situation only 3 years ago when I was looking at starting my own practice. I had legal counsel tell me that only veterinarians could be my partner. So I guess it is an unclear statute at the moment.
Any other questions or comments?
To that point, I don't know really how we left it or how we should go forward on that. If it doesn't seem like an MDC thing, I think we should probably get some direction about. But it would be, I think, helpful for everybody to know what the status is.
So perhaps once we get into the sunset review, we could review the premises registration language, the proposal, and see if there's there are any changes you would like to make to the statute itself to further clarify the business. But right now, what we're trying to clarify is the difference between the real estate and the location of operation. And then further, if you're stuck on that point, you could refer it back to the MDC, or you could ask the legislature for further discussion on that point.
Okay, yes.
I just am wanting to clarify from my own mind where we've left it for the MDC for their next meeting. So you're going to go and get an itemized list of specific concerns to DVMs about practicing under a corporate organization. And then what?
I don't remember what the source is, but from some discussion, it seemed like the proposal for changes, the legal language thereof, did I understand that Tara was going to review some of Bonnie Lutz's suggestions, for example?
My assignment was to look into unlicensed practice and how we could craft discipline against the premises registration holder for inserting influence over the practice itself. I think when the MDC has a proposal that they feel comfortable with and want to recommend to the board, at that point, you would want to take Ms. Lutz's suggestions if those proposals are actually agreed upon. Because right now, she's got suggestions to the current language, but I suspect that language is going to change or get added to. And at that point, Ms. Lutz's good points about revising the language should be made. But it seems a bit premature right now to make those changes because I suspect the MDC after creating a list to identify the most important problems in this area, may craft some totally separate proposals or just add to what you already have before you with the revisions suggested by Ms. Lutz.
So I have three things. Itemize issues, broaden the scope to non-DVM owners, and language review.
Obviously, the proposed legislation and regulations need some work, but just bottom line, does the MDC feel that these proposals and legislations are necessary? Is it something that they want to really work on? Has that already been determined?
It's kind of a broad question because, we all each, who are licensees, we all each have our own personal situations with our employer, and we've maybe had history with both corporate and non-corporate. And I hearken back to Dr. Sullivan's comment. I can see that the caller's concerns, the students' concerns were very real, present tense things that happen in any practice. But, and this hasn't been mentioned yet, it was discussed at some length, one difference between an employee of a large corporation and somebody employed by something smaller is the fear of retaliation should a complaint be made. And again, there was good discussion on this issue. It was pointed out that whatever your position and whoever your employer is, you might find yourself making a complaint and suffering some retaliation consequences. One of the attorneys in the audience pointed out it's not only a big corporation thing. In fact, he used specifically a small-town sheriff situation where a problem happened and this individual has been the town sheriff for 30 years, and I would imagine that wouldn't necessarily go smoothly. And I'm sure some veterinarians experience something like that should they make a complaint. On the other hand, one of the callers who spoke very eloquently and in detail, and I think with some, maybe anger is too strong, but certainly annoyance, she gave me the impression that she's wakes up in the morning and decides whether to go into work or not, and then just give up instead. So I think there's some serious concern about issues that were raised, and it probably will benefit the board if we present you with a list of those things. I mean, then we have, black and white examples of, well, is this a corporate problem or is this just an employment problem? That's how I leave it.
Hi, and again, being ignorant of yesterday's meeting, not being there, I had a question, because Ms. Lutz has been involved in a number, it sounds like she was pretty active yesterday. Is that mostly because your clients are individual veterinarians that come before the board? Is that why she had additions to and thoughts about the rules? I'm not asking Bonnie, I'm just assuming that's why you were so active in it. Well, no, that's true. I didn't mean why personally, but I assumed it was because of the role of representing veterinarians and knowing what things happen.
I think I recall. Yeah, she was just trying to make sure that the language is clear.
Good.
So that when she is representing her clients, she knows what to advise them and how to defend any potential action. So that was primarily my understanding of her involvement, was just to really try and clarify and clean up the language so that it's specific and everyone can follow it.
Makes sense. And then I after we get off this subject, you're going to are you going to continue to talk about the other things that MDC has on its plate right now?
Yes.
Or wants more on its plate? I was going
Any
to
other comments on this topic? Any comments from the public while we're at it? Let's.
Bonnie Lutz, yes, I'd just like to clarify that the reason why I do appear at these meetings and make comments regarding legislation or changes in regulations is not that I have any other axe to grind, except that down the road, I will be defending a veterinarian against those statutes and regulations. And it's been my experience dealing with, for example, old regulations that were very poorly, or old statutes that were really poorly written, that it's very difficult to defend. I mean, you guys don't understand them, the DAGs don't understand them, and my clients don't understand them. So that's really my raison d'etre, if you will.
And we appreciate it.
Yeah, it's helpful.
Any other public comment? Okay, go ahead.
Next item is your agenda item 6B, and if you wouldn't mind turning to that in the packet.
So members, I do want to let you guys know we the MDC meeting yesterday evening, we also got revised version 2 from Tara we can go over those changes, so it's not the same as what's in your packet, but we are pulling it up as well.
May I ask, Jessica?
Yeah.
So on the first page there, the comments, those aren't the changes?
No, so the only thing that was changed and that you,
regarding
yeah.
industrial hemp?
was, I think you and Meg had responded last night that you guys were okay with those changes on the last page.
Yes, so then, if I may, let's scroll down to, I think it'll come up as page 2, at the very bottom. Okay, right, next paragraph, right after advertising industrial hemp. So, let me back up. These are the guidelines that the MDC voted on unanimously at the July 16th meeting, presented to you. They're in your packet as they were voted on then. My understanding is they don't require a 45-day public comment period because they are not regs. They're going up on the board's website as guidelines. And the deadline, as you recall, is January 1st, 2020. We don't have a meeting before then, so we've made one change in response to some excellent public comment yesterday from both CVMA and Bonnie Lutz. In between the April and the July meeting, there was an insertion of this paragraph regarding industrial hemp, as is on the screen right now. The changes to that paragraph made after the meeting are highlighted in my paper, it's red, but are highlighted. There's 3 added sentences. And they were added because there is confusion among licensees and, frankly, from industry, who is perhaps in their point of view, feeling that veterinarians have more license to do what they will with industrial hemp since it was descheduled as of the 2018 Farm Bill. So basically these 3 sentences, and I'm just going to read them. In addition to state the Food and Drug Administration, the FDA, has not approved the use of industrial hemp products for treatment in animals. And in addition, a veterinarian who manufactures, markets, sells drugs not approved by the FDA is in violation of federal law. And the last sentence as written there. And use of such products should only be done after industrial hemp product has been approved by the FDA for use in animals. I'll stop there and ask for questions. We don't have, as an MDC, another opportunity to address this before the deadline. And I might add also that further in your packet under legislation, there'll be SB 626 addressed. You're probably familiar with the status of it, but Jessica was at the meeting in July that occurred right before our meeting, and then after your vote on that legislation, the bill was pulled and is now a 2-year bill. But the tenor of the discussion, whether everybody agreed with what we should do, is that we, as an MDC subcommittee, are going forward with guidelines that won't be a separate guidelines. They'll be expounding on these that were based on AB 2215. And you may or may not recognize whatever familiarity you have with the medical board's guidelines. The basis of these, kind of the outline of these guidelines in Agenda Item 6B, are from a loose outline of the medical board's guidelines. And I've reviewed those numerous times. They include an appendix. Dr. Nunez actually added a concern at the last meeting when I gave the report and we were addressing these single items. And his concern was at the outset, before cannabis is even discussed, have we exhausted other products, other things to use? And that's on this algorithm, they call it a decision tree, Appendix 1 of the medical board. That's the first square. So things like that, we don't specifically have in these guidelines because these weren't written for SB 627, but we're going forward with the anticipation at some point that bill or something like it will be passed.
Thank you. Any comments, Tara? And then Cheryl.
You see a bunch of pink boxes. I'm prepared to discuss my proposed revisions when you're ready. Dr. Waterhouse, if you want to go first, perhaps.
I have one more change that I would make, and that's under guidelines.
Can you turn your microphone on, please?
Sorry, I keep turning. Sorry, I have one word change. On the first page, under guidelines, under the heading says guidelines. It says in instead of on.
It's been changed already. Oh, no, it hasn't. It was changed somewhere else.
Right, it's changed at the end of the document.
Veterinarian?
But I actually have a suggestion to strike that entirely.
I'll be quiet then.
Okay.
So I want to follow the statutory mandate. So I'm proposing that the title of the guidelines change and a couple other descriptions of what these guidelines are about so that we're meeting the mandate specifically. So my first suggestion is in the title, if you could, if we could see these changes being made at the same time, that would be helpful. So what I'd like to do is in the title where it says guidelines for the discussion, I'd like to strike the and insert veterinarian. And then after the word cannabis on that second line, I'd like to insert within the veterinarian hyphen client hyphen patient relationship, and then strike the rest of that use for veterinary patients. So this is just to match the language in Business and Professions Code Section 4884, Subdivision C. And then in the preamble, that first paragraph, line 4, where it says guidelines for discussion. After 4, I'd like to insert, so it would say guidelines for veterinarians to follow when discussing cannabis, to follow when discussing cannabis, within the veterinarian hyphen client hyphen patient relationship, open paren, capital V C P R, close paren, period, and then strike the rest of that sentence. But keep the number 1. That's a reference to the index at the back of the guidelines. One more change. Lower on that page under the heading guidelines, that first paragraph after cannabis on that second line, insert within the VCPR, period, and then strike the rest of that sentence. I'm sorry I didn't bring these issues up at the MDC level. It's just I was comparing 627 and then I was looking at 2215 and realized that this needed to be clarified.
Dr. Waterhouse.
Turn my mic on. Okay, so same idea.
Can you
but
still
in
speak
different-
into the mic, though?
Same idea, but in a different location. So under the preamble, so third line down, have it say in the animal instead of on the animal, unless you want to only consider topical use.
Okay, so I just want to point out that AB 2215 actually says on.
Is on.
Yeah, but for our purposes, you know, perhaps it's better to use in.
How could we allow that original transgression to occur?
Well, that's the legislature. We didn't write that.
Okay, further comments?
What about if we just say for an animal rather than in or on?
Because you're using,
I don't want to stray too far from the statutory language.
Okay. And then I had one more question.
any other comments? Yes, Dr. Bradbury.
This may not matter if we're going to be adding to this after the other one. I was just, when we were talking about with the bullet points here, for the documentation that may include advice about, the very last one says the importance of periodic reevaluation of the patient in accordance with good veterinary practice. I guess I'm just confused about that, if we're not recommending the use of it, and are we reevaluate? I mean, obviously, I'm not sure how that relates if we're not recommending the use of it, and are we reevaluating its efficacy if we're not using it?
The thought was, I remember that discussion, it was compare introduction of cannabis in the patient's care to an NSAID. So most of us are going to recommend, depending on the condition of the patient, the age, et cetera, periodic blood work at 6-month or 12-month intervals. So we went back and forth through a couple of options to keep it as broad and general as possible, and that's what we came up with. So it was intended to avoid the scenario where, okay, we've decided on cannabis, go in peace. and not see the animal again. That's not what we want to see happen.
Dr. Nunez.
I'm in favor of keeping it, the word on instead of in, because of Tara's concern of making it consistent with which the legislation. I don't agree that on only applies that I'm doing something topically. For example, I have started fluid therapy on Fluffy the cat. I'm not applying fluid topically. I'm applying it intravenously, but the term is I've started fluid therapy on Fluffy the cat. So,
I say
and a consensus.
I say in, but I don't know. It's not.
To keep it consistent with the legislation, I concede to Tara's point that we should keep it as on.
Thank you for all your work.
We're not done. I think the reality is this is going to change pretty soon. Just in the outline of SB 627, there was a deadline for January 2022, which sounds like a long time away. But you know how that goes.
Okay, any other comments? Have we decided on the verbiage? Are we using in and on?
Tara,
Tara, it's a-
yeah, I think your call on
We have
this,
a decision on the verbiage?
should it be on or
I think we're aiming this toward veterinarians, not the legislature. I think if there's a preference for in, so that it, it's clearer that it's, potentially ingested or topical, you could go with in, just so it's clearer to the professionals. I think that's fine. I mean, I don't think they're going to catch it, but I just want to make sure that it's clear to you guys. I just don't want to stray too far.
I think we're speaking to two professionals who have different opinions.
I get my IV fluids into the animal, but
Okay. Any other comments?
I was supporting you, Tara, and you just threw me under the bus.
Any public comments? Yeah. Maybe Bonnie can clarify that wording for us.
Well, I didn't really have a comment on in and on. No comment. I don't really care. But I have a question for Tara, and correct me if I don't know. Was that standard of care language in the bill? I mean, a little concerned about these guidelines are not intended to mandate the standard of care. And the reason I say that is that, I've told you, I've been approached by several attorneys for companies that are producing industrial hemp products and are very aggressive about, pushing them onto the veterinarians. And I'm always a little, as a lawyer, I'm always a little concerned when you use that term standard of care because you don't really like to have it thrown back in your face coming from the other side. So what I anticipate is somebody coming back to me and saying, well, those aren't standard of care. My clients, there's nothing in that says that the vets can't put industrial hemp products in their offices and sell them. I mean, I just wonder if that's there because it was in the bill, and if it was,
No.
then I understand.
Right, standard of care is not in the bill. We're trying to clarify that we're not dictating standard of care through these guidelines. We're just trying to do the statutory mandate, which was guidelines for discussing cannabis within the VCPR. So this is not about trying to list everything that they should be doing, and as soon as you check off those boxes, you have resolved any standard of care issues.
Okay, but we never write, it's a practice among lawyers, we never write down the standard of care. I mean, it's an evolving thing based on expert testimony. So that's why I always have a problem, when the shelter guidelines came out and they called them shelter guidelines for standards of care in shelters. And we all went crazy because we said that's really bad because that's going to be dragged into court as a standard of care. And it's a changing thing. So I would like to see that language removed just because I don't think it adds anything. And the board doesn't have standards of care for veterinarians anyway. I mean,
Correct.
it's up to expert testimony.
And we're trying to let professionals know that this is not going to meet a standard of care. This is not about providing a list of items to check off to meet standard of care. We're just trying to let the professionals know that there's more to it. This is just guidelines to have a discussion.
Right, but that's why I would suggest that you leave that language out. I mean, standard of care is a particular legal term of art. And when you start using it, I think you open up other questions. So while I understand what your position is, you as the board haven't got any other documents where you say this is the standard of care, or this isn't the standard of care. In other words, when somebody decides the standard of care, it's the expert who gathers together all the basic information and looks at what doctors actually do at the present time, and then decides what's the standard of care. So, I mean, I just am always concerned about the use of that term in a document when it's not really necessary.
Well, I would ask the licensees on the board or in the audience to chime in on this one. Is adding that statement helpful?
So,
Because that's the only reason it's there.
Okay, Dr. Bradbury.
I wanted to point out that you had mentioned that a lot of the things that are written previously by the board are poorly written. And because it hasn't mentioned this before, doesn't mean it shouldn't have been mentioned to make it more clear. So I don't know that it may be helpful to make it more clear. I can understand wanting to say to us, hey, this isn't going to protect you in a court of law. This isn't saying if you do this that you are meeting the standard of care. I think it might be helpful to practitioners to have this statement in, but that would just be my thought.
Generally, it's not a good idea to write down standards of care one way or the other. I mean, I think if you talk to any malpractice attorneys, they'll agree with you, because then they tend to last forever. So my concern is just that there's a particular lawyer with one of these firms that's pushing these industrial hemp products, and I can guarantee you that she's going to be on the phone when she sees that to me and say, okay, well then that means that they don't have to follow any of this. They don't even have to be concerned about the fact that it's not FDA approved, because this document says it doesn't mandate the standard of care. So I'm looking at it from my answering questions from that other side.
I guess I'm wondering, I don't know that this is mandating anything. This is just following these are just supposed to be guidelines that are published. I don't know that we have to, they're not regulations. They're just something that the legislature asked us to put up on our website, I think. Am I incorrect in that?
They become the standard of care anyway. So let me just say another thing. Whether you say it isn't intended to be the standard of care, it becomes the standard of care. Anything you write becomes the standard of care. So if, for example, there's a vet out there and the vet has industrial hemp products in his office and he uses them and an animal is harmed and the person complains, and then you are investigating the complaint, and your vet or some other vet reads, the case and says, well, they were given all this guidance. I mean, they were given the guidance that it's not FDA approved, and they, yada, yada, yada. It still becomes the standard of care. You're saying this is not intended to be the standard of care. It doesn't take it out from a legal perspective of becoming standard of care. Anything you write or publish or anything that's out there can be used by an expert to determine the standard of care. So that's my concern, is that even using that wording could be used potentially against us, and not having it in there doesn't really change things. That makes sense.
Okay,
Kind of a legal nuance, if you will.
Who needs to talk next?
So, my question is, why was the sentence put in there?
To make sure that people weren't trying to rely on these guidelines as meeting any particular or satisfying anything with respect to how to treat the animal itself, just to, limit the scope of these guidelines just to our statutory mandate. These are not guidelines on how to treat the patient.
Can we say
So
that?
my understanding is that's what guidelines are. If they're not in statute or not regulations, they're just guidelines.
Mm-hmm.
So that, you asked what my, opinion of it. I don't need that sentence to make me know that they're not. That's what I'm.
So can we just say what Tara said instead of saying that sentence? Can we put it in there that these guidelines are meeting our legislative duty and they're not intended to,
That's
what
what
did you
we're
say?
Okay.
Sorry, just real quick. So I understand that, I understand the, well, I don't think it's an argument, the comment that having that in there can go one way or the other, but not having it at all, just keep these as guidelines. Because yes, then as an attorney, you argue, well, these were the guidelines, and so why isn't this a standard of care, regardless of whether or not that sentence is in there? And if other guidelines haven't placed that in there, then perhaps we're then creating a precedent that some things are standard of cares, some things aren't. So I would agree that if these are guidelines, and as practitioners, I mean, I'm not a practitioner, right? You all understand these are guidelines, then I feel it would be safer to take out that sentence and let them be guidelines. And however attorneys want to argue, attorneys shall argue.
That's what I was going to suggest.
Public comment on that?
No, that's all. Thank you.
Okay.
With Ms. Lutz's description of the potential arguments and Ms. Prado's additional testimony, I think that it's a good idea to take it out.
Okay. Is that something we need to agree on, or we'll just, when we do a final motion, we'll? Okay, any other comments? Anything, Dr. Pollard, you would like to add after that discussion?
On cannabis, no.
Do we want to make a motion? I mean, it's time.
Yes, so you would make a motion to.
Does anyone want to go ahead and make a motion to approve as amended this guidelines that have been given to us?
I will make a motion to approve the
Dr.
guidelines.
Dr. Bradbury's made a motion.
As amended.
And you're
As
sure we're
amended.
keeping it as in?
Anyone want to second that?
I'll second.
Okay, Ms.
I'll
Bowler
second it on
seconds. Call for the vote. Oh, public comment again. I forget that all the time.
Ms. Bowler,
Oh, yes, I'm sorry.
Dr. Bradbury?
Yes.
Ms. Laredo?
Yes.
Dr. Nunez?
No.
Ms. Prado?
Yes. Because of the all.
Dr. Waterhouse?
Yes.
Dr. Noland?
Yes.
Motion carries.
So, Dr. Pollard, would you want to continue with
Yes.
anything? Yes, thank you.
Last item
And they all said, oh.
on the agenda regarded shelter medicine guidelines that were approved at the April meeting. There was some pushback from public and animal welfare organizations. We had a discussion about some of their concerns. I'm sure you're familiar. Two things that I think I took away from it. One, Dr. Miller of the CVMA graciously offered, after speaking to a shelter business group in a couple of weeks, October 29th, to share with us his findings. And two, Dr. Sullivan on the MDC in the discussion pointed out that in some of these rural places that are having hard times finding a veterinarian to sign up for their duties, to view the problem as more of a herd health model rather than a small animal medicine model. Idea being a veterinarian in large animal goes from farm to farm and has protocols that he or she dictates, and the animal is treated accordingly. And when there are specific problems within the treatment under those protocol, then the veterinarian personally gets involved. And there was one other item, I believe Jennifer Laredo mentioned it with regard to consulting with UC Davis shelter medicine people and seeing what help they might be able to offer us to the issue.
I think I stole that from someone else, but I'll take the credit.
Okay, comments on that from the board? Yes, Dr. Nunez, and then Dr.
Could you
Waterhouse.
address also, there was a concern that local veterinarians in these rural areas were concerned about their liability in providing services to shelters?
Yeah, thank you. Thank you for reminding me. There was discussion about whether there should be a differential level of liability. So big shelters that have a veterinary contract, they follow the rules as written. And should there be some lower level, and even the mention of a different license status was mentioned. I didn't get the impression it was very enthusiastically supported. So I don't know what direction we're going to go with that.
Any other comments from the board? Yes, I think Dr. Waterhouse was next, and then Dr. Bradbury.
So I was just going to talk about what Dr. Nunez brought up. And so if you remember at our last meeting, there was a representative from the Kings County Sheriffs. And so last week I called and found out that the Kings County Animal Shelter is located in Hanford, California, which isn't that far away from Fresno. But there is a veterinary practice in Hanford, a 4-doctor practice.
But
So that's doesn't make any difference. All he needs is a veterinarian. But no, actually, it's a small animal. They do a fair amount of small animal there. And so they're not that far apart. There are veterinarians available. And I spoke to the practice manager there, and they had been asked to be on the premises license, but they're worried about, as I could understand, putting their name on a license and being legally liable for a place where they might go once a month, or, animals come to them as needed for surgery or whatever, but they're not going to go out there every day and make sure that everything's being run according to our standards. So I think the herd health approach is the right approach, but that's a big holdup, is these veterinarians don't want to be the legally responsible one.
Okay, Dr. Bradbury?
I was just wanting, I wasn't at the meeting, so I don't know what the herd health approach was. Is this like sort of developing an exception or
Protocol, so animal comes in with a wound, what?
Yeah, no, I know, but we have this whole shelter medicine thing that we've done now, and then we got these public comments, and we've gone back to the MDC. And so are we going to amend it to have some exemption, or how is that going to be written into what we're doing so far?
I think Jessica clarified that there was a comment made that needed clarification. The guidelines have not been withdrawn.
The shelter regulations, as the board may recall, were not withdrawn from the board. They're still moving through the process. But the board had asked the MDC to discuss ways shelters may be able to recruit veterinarians. But the actual regulations are not being removed or amended. They're going through the regular process.
Dick Sullivan. I just wanted to clarify in that when we've set up these shelter standards, there's different grades. It's not everything across the board. So if they're not doing surgery, the level of that permit is at a lower level. If they're only doing intake, vaccinations, and preventive medicine, that's another level that they just need to satisfy. So I think we've addressed a lot of flexibility there. I do see that in a small community, as Cheryl has mentioned, some difficulty in that veterinarian signing a premises permit. Maybe we need to work on that part of it and explain that a little bit more thoroughly. But I just think it's a doable thing, and maybe there's a lot of misinformation out there that hopefully we can work through.
Thank you. So where do we go from here? I guess my opinion is that we're called to protect the consumer and to protect the animal. So in my mind, if we have a rural area, and obviously Hanford maybe is not as rural as I'm thinking, in order to protect the animal, having limited availability of a veterinarian is better than having none. And I think we need to figure out how we can make limited availability a realistic alternative. That's my feeling about it. Because I do really think there are areas where we aren't going to have a veterinarian on premise, and when we're not going to have maybe the kind of availability that would be important for animal welfare. That's my personal opinion. So I guess I would say maybe we do need to continue the discussion and try to figure out, and according to the organizations that I've heard talk, they think up to 25% of practices are like this. And I don't know if that's a realistic number, but I do think there's enough that, we ought to be looking at it further. Tara.
No, go ahead. I'm just concerned about trying to do something that we can actually accomplish versus continuing to have discussions about stuff that they can already do. So today, they could have one veterinarian who services multiple shelters. That's existing. That has nothing to do with the shelter regs. It seemed to me that the shelter's biggest problem was that they didn't want to have to be registered as a premises because and their argument is that they're unable to find a veterinarian who will lend their name to be the managing licensee. That would require, if we didn't want shelters to have to do that to resolve this, vanishing veterinarian problem, we would need to go to the legislature for that, because we can't just exempt entities from registration. It's statutory. So I want to be clear on what the goal is, that it's something that we can actually accomplish versus something that if we're trying to figure out the veterinarian problem, perhaps since they can already have, one veterinarian can be the MGL to many shelters. I don't know what else we can do to encourage veterinarians to step up and volunteer for that or to do that. I mean, we could do like an outreach campaign, something like that. But as far as the regulations themselves, we're kind of at a standstill with that.
Well, can I ask Dr. Pollard, didn't they come forward with some wording that they were looking at that they would like us to consider as a group?
Not yesterday.
I think I remember that.
It was
from earlier.
legislative, and they wanted a flat-out exemption from any registration
I thought there
or,
was something to do with preventative vaccines, and I thought it was a fairly short list at one point. Do you remember, Jennifer?
it was limited to certain types of veterinary medical practice at shelter locations specifically, but it was creating an exemption from the Practice Act, making them no longer subject to premises registration, even though these locations, veterinary medicine could be practiced for limited purposes.
To address your comments, Tara, I do think that some of the licensing managers' duties are under regulation. And maybe we could address some of the responsibility of that licensing manager in a shelter under regulation as opposed to having to go to the legislature for a statute change.
Are you suggesting some kind of, what does that look like? Does that mean relieving them of needing to make sure that the premises is sanitary? Do you know what I mean? Like the MGL has specific duties and they're.
Yes, but we've done a whole section on shelter medicine, carved it out as best we could. Could we not, under the licensing manager, carve out certain responsibilities under the condition of shelter medicine? These are the duties of a licensing manager, to help take away some of the liability of making sure that that person who is a trained veterinary assistant is not doing more things. I don't know, I'm just suggesting because the specifics of a licensing manager is under regulation as opposed to having to change statute.
Yes and no. Some of it's statutory, but the whole point of the statute itself is making some person who's familiar with what a veterinary practice should look like and how it should be run, making them responsible for the premises because we have otherwise non-professional owners. So somebody's got to step up and make sure that everything is up to code, and perhaps it's up to regulation for just that type of location.
Yes, and I think we addressed that with the premises permit by including shelters on the registration of a premises permit, including shelters having to register as the licensee for the shelter, for the premises permit.
Right, but then do we have non-professionals making sure that the premises itself is sanitary and clean and because that's really what we're talking about. It's about who's going to be responsible for the facility. And if we're trying to remove some liability of a veterinarian, what does that really do? Yeah, I know. I know we've got to find some resolution here, but I'm trying to just,
Dr.
remind
Waterhouse.
everyone we have limitations.
Dr. Waterhouse and then Ms.
And
Bowler.
that's why they're having a hard time finding veterinarians. And I am not going to put my name, I'm not going to be an MGL with shelter when I don't go there but maybe once a month, even once a week. I'm not going to put my name, I'm not going to be the legally liable person when I don't have really full control over that shelter. I am the MGL of my practice, but I know what's going on there, I control it. You're not going to find veterinarians who want to be, they are not going to step up, they're not going to volunteer. I wouldn't either. So there needs to be some kind of middle ground, I
Yeah,
think.
because then they're operating outside of the law, not due to their choice oftentimes. I think did you want to respond, or Ms. Bowler?
Yeah, really, partially, that's what I was going to say too. I mean, I think the regulations that we've got moving through the process, I'm very comfortable with. I'm not comfortable with blanket exemptions. I understand the problems, and I'm wondering if there's a way, with what Dr. Sullivan said, to look at some without making it, without sort of impairing public protection, consumer protection in any way on the shelters, but making some way for a vet that is not there presently. I mean, maybe we can address this, and maybe there is a regulatory way. I don't think we can do this today, but it might be something for MDC to go do a deeper dive into to see if we can address some of those things, in addition to the recruitment and advertising and sort of communications with veterinarians in those areas where they're having trouble finding them. But I guess I, as a consumer, wholeheartedly agree that if that's the practice of veterinary medicine, and that's a premises, and vaccinations and parasite control, et cetera, are in that, then then those facilities must comply some way.
Mark and then Dr. Bradbury. Dr. Nunez.
Ms. Bola already said what I was going
Okay,
to say.
then Dr. Bradbury.
So it sounds like they're going to be going to the legislature anyway to try and get this exemption. They're in a rural area that is underserved, and is it something that we could propose or put something together for the legislature about having state veterinarians be involved with the rural areas? I don't know well, I think that they're going to, they're not going to just sit down, so, but I don't know what role we would play in that, but it sounds like this is something that the public, does need these shelters in these areas for their protection, the animals' protection. We can't, we're not funding those. We do need to require that they have certain standards for the animals and to protect them. But at some point, maybe it is a state veterinarian that is overseeing those sorts of things, and I don't know how to ask for that help.
Laredo.
So it's unfortunate that CAWA isn't here to kind of address some of these issues, but to your point, somebody somewhere is in charge of these facilities now. They are run by some sort of entity, and somewhere there is money. So with the county facility, there's the county veterinarian, so maybe the state veterinarian, maybe they need to be state-run shelters. The whole purpose of this was consumer protection because there was no oversight in so many of these facilities, and a blanket exemption is not a good idea. I think we all agree on that.
That wasn't
But
what I was suggesting.
somebody is
Yeah.
running these facilities. They're not just in somebody's backyard, hopefully.
Yeah.
Hopefully they are not.
So Dr. Pollard, anything else?
Yes, two items. In my chair remarks, I pointed out the committee member term expirations for two reasons: to avoid vacancies and ensure there's adequate notice for applicants. Recall the last MDC member appointed was one of a number of very qualified candidates. So for whatever crazy reason, there are people out there that really want to do this. So we want to give them every opportunity. So I'm going to continue that. And the other item I would like to mention is, as a result of the board meeting date changes from Tuesday, Thursday to Wednesday, Friday, I'll no longer be able to give the MDC report to the VMB, and Christy Pulowski has generously agreed to do that. She's vice chair, so she's eminently qualified. So she'll be giving the next one in January.
Yes, Ms. Bowler. No, Ms. Laredo. Ms. Bowler's over there. Getting close, yeah.
I wanted to just comment on the issue of the MDC positions. When we do have the open position, I believe it was in June that we have some position openings. Previously, there was an interview process, and I took issue with the way it was done. There was a member who was eligible for reappointment, and they did that interview first, just assuming that that person would be reappointed when there were other candidates. So I think that's unfair in the interest of putting people on the spot. So when we have however many openings, I feel it should just be the pool, whether somebody is eligible for reappointment or not, have the pool available so that we have one position, two positions, and we're choosing from everybody rather than assuming that somebody is going to be put back into that position.
Okay. Any other comments? Okay, thank you very much for your report. And, now we have Ms.
Yeah, sorry. In other MDC meetings in the past, there's been a subcommittee, I think maybe it's still in existence, that's done a review of the complaint review process, et cetera, et cetera. I was wondering if there was a report on that, and if that was still going on.
It is still going on, and no, there was not a report yesterday. Nothing has transpired since the last meeting as regards to the subcommittee.
Okay, thank you.
Okay, we're going to go ahead and take a break for lunch, and we will resume at 1 p.m., 1:15. Jump back, because we did have the DCA come back to join us, thank you, and they brought us some numbers, so I think it was item number 9 on the agenda. And board members, in front of you, you should have an analysis of the fund condition based on the scenarios that we asked them to run. Give us a moment to take a look at that.
And I just wanted to clarify that
Yeah.
the first one is the one with no changes to the RVT fees, and the second one is the compromise that you guys came up with regarding $200 for VA, $250 for C, and then $200 for D. So.
And I do want to remind members about the statutory requirement that our fund is no less than 3 months in reserve.
Yeah. And, yeah, so.
So according to this, we're already less than 3 months in reserve.
Right.
In both scenarios.
Well, I mean, we are currently
Yeah.
already. Yeah, thank you. It's not that it's going to happen, it's already happened.
Yeah.
Okay.
So do you mind just going over briefly the two scenarios that they're looking at?
Yeah, of course. So, yeah, as I mentioned, the first one, it has all the other fee increases other than the RVT. But even with that, although the fund is over 0.0 for fiscal year 2020, 2021 and onward, it's still not at that 3-month reserve mark, which is quite necessary to even seek any additional resources, especially in regards to enforcement, to reduce that workload or the backlog and such.
So can I ask a question about that? So you said in order for us to receive more funding, we have to meet that requirement of 3 months reserve?
I think Karen could probably answer
Okay,
that a
thank you.
little better.
In order to request more funding, our control agencies would like to see a reserve that, because our months in reserves are in case of emergency. So if something were to happen, revenue doesn't come as projected, or if expenditures exceed what we are projecting, that's what that month in reserve is for. So if you're asking for additional resources and they're seeing that your fund is declining each year or is just at a low minimum of 1 or 2 months, the additional resources would probably not be considered. So we'd like to stay at least within a 3-month with a plan in future years. So with the two scenarios, even with the second scenario, we're not even showing a 3-month reserve.
Yeah, so I guess my question then to follow that train of thought is, if we're already drowning here and we do raise our, up to our maximum caps, we're still not going to make our minimum. Are you going to be lenient as far as giving us extra funding at that point? Even in the best case scenario, when we raise everything to our maximum caps, we're projected to not make our 3-month reserve.
So yeah, with the statutory max scenario that I showed earlier, yeah, you're correct. It's at 2.5 months in reserve for fiscal year 2020, 2021. But for the year after that, you could see there's a big jump to 4.4. I don't know if that's printed on yours, but yeah, so with 4.4 and moving forward, it would, you could assume that it would be even higher, projecting for future years.
With the caveat that no additional resources would be added.
Right.
So even though it shows us reaching above and going to 4 months in reserve with the increase, if we were to request any additional resources, it would not go that high.
So when we're talking about additional resources, it's not really getting money from anybody, it's reallocating what resources we have for a different purpose. Am I understanding that correctly?
The additional resources that you guys would be requesting would be additional appropriation to the fund.
And that additional appropriation is earmarked for additional staff only, or for whatever we end up needing to budget for?
Yeah, it just depends on what kind of resources that would be sought. So if you're requesting additional staff with the salaries included, operating costs and so forth, that would be the fiscal part.
Yeah, Jennifer.
I just want to make sure I'm understanding this correctly. So on the handout we just got, it looks like these changes would be implemented in fiscal year 2021, is that correct? The last two columns?
Yeah, it would be fiscal year 2020, 2021, so like July.
Okay. And at the bottom of that, we have the reserve for economic uncertainties, $446 on the first one, is that?
Or it's in
Or is that in
thousands.
thousands?
It's in
Okay, I
thousands.
feel better.
Yeah.
Yeah, Kathy.
I'm just starting to glance at this, but this is probably a stupid question, but bear with me. Why is the big jump what, is it because we've been eating into, because between, on the original proposal, 2.5 to 4.4? Is it because we're underwater now, and as soon as these fee increases go in and are fully enforced, or fully in place, that's how there's a big jump between 2021 and then the renewals? It's just the cycling of the new fees?
Yeah, exactly. And as you can see at the bottom of budget year 2020, 2021, where it says fund balance reserved for economic uncertainties, it's 1,270, which is actually $1,270,000. But that then is the beginning balance of 2021, 2022. So it's just such a big difference because those fees took place, and that's why the number jumps exponentially.
I see, and I see the year before. Okay.
Oh, I have another
Yes,
question.
Jen.
If we were to raise the statutory cap, how long does that take to implement?
So to raise the statutory cap, if we are requesting that to be part of our sunset, we would get a bill in 2020, and the bill would take effect January 1 in 2021.
Christina?
So if we're struggling to get by now, you won't help us, but if we tax or increase our fees, and we're not struggling anymore, then you'll help us. Am I understanding that correctly?
I need to clarify, it's not them
It's not-
helping
I know not
us.
you, but you're the office that you work for.
It's
It's not them.
still not them either. It's the budget process, and it goes in the governor's budget, and
Yeah.
this is much bigger than
But
them and DCA.
that's, okay, so not you, sorry. So the governor, so the state won't help us unless we aren't in trouble?
So so they can't give us resources in the form of staff unless the fund itself can sustain them, because they won't let us overextend what we bring in. So until we raise our funds to sustain what we're asking for, they're not going to let us overspend that.
What if we were already at our limits?
So you're asking if you're at your limits and you can't do, and you absolutely need these funds? I mean,
This is about the people of California that we're trying to protect, so that's just I'm just curious.
Understood. And I'm sure that there could be other avenues. We could request resources within DCA where, you can ask for some assistance from one board or bureau or someone within DCA to assist in that time for a short period. But we're assuming that we're looking at the situation ahead of time to resolve this issue, so we don't have those emergency cases. That's why we always look at your fund at a 3-month reserve. So if you drop below 3 months, then we are requesting to raise fees, or we're going to the legislature to ask for a bill to raise caps at that time. So I think we're still we're still at a point where we can raise those fees. One thing we did bring up with Jessica when we proposed these two scenarios was that there is an option to raise RVT fees for one renewal cycle, so a 2-year limited term type raise of a fee. So you could increase those fees that are at statutory cap, premises, veterinary licenses. You can raise those fees at cap, and then it would only be a one licensing renewal cycle for each RVT, just for a temporary situation.
Yeah,
That
I
is
think
something
that's
that
a
we
little
could
bit more
look at as well.
palatable, I just really worry about them, honestly, it's not that I think that we need the money, and I understand the need for a budget, I'm just really worried about
Right.
the inability of these people to pay.
Right, and it's not that
It's the amount that we're
won't
raising
help
it to.
when there's a situation like that, it's just that the governor, the state can't issue additional
Funding.
resources if the fund can't sustain it. So,
Yeah.
we're special funded. We're not in the market of making money, so it's not
Right.
like we could exceed that budget. So you have a checking account, and if money is gone,
Right.
No bridge loans, I guess.
Right.
I have a question about, it
Sorry,
looks
I
like.
don't understand it all. I apologize for the questions.
No, we have, you have two categories. One is the renewal fee increase, which looks like it's by far, since it's where we get most of our revenue, it's going to jump the most. And then there's the other regulatory licenses and permits. And it looks like in the two scenarios that you've brought us, those are lower than this one. Can you clarify what exactly those other fees are? Are those late fees?
Initials.
The initial?
Yeah, so
those
those,
are the initial or application fees, any of
Right.
those fees that go up. So we have delinquent, we have renewals, and then any of the other ones that are.
Registration, initial application.
Anything outside of the DVM and the RVT renewals?
Anything outside of renewals period.
Okay,
So there's one
okay.
just for renewals, and there's one just for delinquencies, and then applications, the initial license fee, those fall under that third category.
And I'm assuming that you used current renewal numbers and current approximate new licensees when
Yeah,
you
for
did
that first fund condition, yeah, which I believe those numbers were roughly around $150 or so, 150, like
Yeah.
150 or so. And then for the compromise, you guys asked for 200, 250, and
Yeah.
200.
Jennifer?
So I realize that we can't do anything else with premises permits right now because we're already at the cap. But what we're looking at in front of us, I don't like the idea of balancing the budget on the backs of veterinarians any more than I like doing it to the RVTs, because that is quite a big jump. So my suggestion for this would be maybe I don't want to raise RVTs at all, so I'm definitely looking at option one. But for the veterinarians, is that we do it with the timeline that was just discussed, and then maybe when we get our statutory cap raise, we reevaluate it at that time. Because in this scenario, veterinarians are taking a hit twice. They have to pay more for their licenses and their premises permits if they have them, when I think the only category that could theoretically afford this would be the premises permits.
Which we can't. Any other comments? Looking for my sheet. Oh, here it is.
I think we're done.
Yeah, I think so too. But can I?
Yeah.
I don't want to send these guys back for another recalculation. But if we were to do something, and this isn't going to be the final phrasing, but in the way of raising all the fees right now, the first proposal to the caps, however, having the RVT increase basically sunset out in the I guess it'd be 21, 22 fiscal year, maybe?
It's a 2-year, probably, has to be.
And then, at the same time, couple that with immediately going to the legislature or going to wherever to increase the caps on all categories for going forward. Would that give us some cushion? Unfortunately, RVTs would pay a little more for a little bit, but it would reduce back after, and that would coincide with when we've raised the caps on all the other fees and licensing, that we could then increase those more if we needed to. That would be on-premises permits and things like that. I don't even know if that's even a workable.
Yeah, that was a suggestion that we could do. So we could raise all fees to statutory cap through the emergency rulemaking, and then during sunset, we could reassess the cap to raise, and then make the RVTs just to be a 2-year temporary fix, and so it would actually put them through a 1-year renewal cycle, and then RVTs would revert back to their current fees, or you could, however you want to make it revert back to 200, or however you guys compromise on that, but then we could raise fees or look to raise fees for other areas.
So I'm going to jump in and ask a question. So, there's obviously 2 ways to balance a budget. One is to get more income, and the other one is to decrease spending. I can think of two things that might account for this. One I can think of is the Breeze program cost us a lot of money to implement, but the other appears to be the increase in complaints and ability to discipline the complaints and ability to follow through with complaints with the AG's office and whatnot. Does anyone that knows more than I do in this room know of a way to decrease our expenses at this point? And is there a chance that we could?
Neither one of those things can be decreased.
And am I right in assuming those play a fairly substantial role in this problem? Or
Yes.
is there something I'm missing?
What was your first one? I didn't get your first
The
one.
first one was the Breeze. Implementing the
Oh,
Breeze
Breeze.
never cost us a lot more than we'd hoped. It was very expensive and very time-consuming. It cost a lot of time, I think, labor as well as, expense. And the other one was the increase in caseload that we have.
So,
And, well, you and then you want it then? Go ahead.
so Breeze costs us what, about $250,000 a year, in the ballpark.
That we didn't use
And
to.
there's, and then we're told how much that is, that dollar amount, right? We're not,
Yeah, and it's also in the sunset report. It's something that the legislature asks every sunset report. So we have a breakdown of how much we spent so far and how much is projected to spend in maintenance costs.
and every time we ask for a correction or a change in Breeze, is there a cost associated with that? Or
No,
just-
that's part of
covered
the
under our-
maintenance. Yes.
But, I mean, there's nothing we can do about Breeze costs, right?
No.
Yeah.
It's mandated.
Nancy, would you like to public comment? Thank you, Vidal.
Nancy Ehrlich, the California RVT Association. I'm glad you mentioned reducing costs, because it seems obviously the largest cost is the AG's office. And have you considered using cite and fine more often rather than referring things to the AG's office? That could save an awful lot of money. And I'm concerned that if you increase fees on RVTs, you're going to end up actually reducing your income, because RVTs will not renew their licenses. In many hospitals, RVTs are not treated very much differently than veterinary assistants, and they say, why am I paying all this money so I can be an RVT when I don't get anything out of it? So I think you need to take that into account, that you may end up losing money rather than gaining money by increasing RVT fees.
Are you suggesting they'll not renew their license?
That's right. And you're talking about increasing the premise permit in 2021. So the budget would problem might be solved by 2021. And I suggest when you look at increasing the premise permit, that one of the things you consider is charging by the number of veterinarians employed in the premise, rather than just everybody paying the same fee. A 20-doctor practice earns a lot more money than a one-doctor practice. And, you could have a sliding scale based upon the number of veterinarians, and I think that would be much more acceptable to the veterinarian public than just raising it for everybody. I mean, I could see a large practice paying $1,000 and a small practice paying $200 or something like that. And I think you need to seriously consider that. And of course, we're talking about potentially the AG's office reducing its fees. That everyone agrees that this is an outrageous fee increase, and potentially that will be solved and you won't be in such a problem. So if you start looking at how to reduce costs by using more cite and fines rather than going to the AG, and then anticipate that hopefully you'll be able to solve the AG problem by getting them to reduce their fees. And then consider that if you raise fees too much, you might end up losing money rather than gaining money.
Yeah, thank you.
I would just like to comment as far as using citations in lieu of going to the AG's office. If we ever got to the point where we feel like discipline is necessary, we would not be pursuing a citation. They're served for two different purposes, and if we feel that they've met the criteria that raises to the level of discipline, then we need to pursue discipline.
Grant?
So Grant Miller, CVMA, thank you for that comment regarding cite and fine. I'd like to point out that the Medical Board of California and the Dental Board, the Dental Board charges $400 for their license for a dentist. When a complaint is levied against a dentist, their policy is to collect records only from that visit. And the Veterinary Medical Board collects any and all records and then also does a site inspection. If you're looking to limit costs relating to some of these issues, you might want to consider the policies that you're using when you investigate complaints, because these other boards, my suspicion is that by the sheer size and number of complaints that they have and the size and number of licensees that they have changed some of their policies to be able to actually make their workload possible. And I've always contended that our profession is a very well-behaved profession, which has created a luxury in some ways because it's given this board the opportunity to do investigations and a scope of investigation against complaints with us that the other boards just don't have the bandwidth to do due to the number of complaints that they get. So it might be worth looking at the policies on how you guys investigate these things to determine, the extent that you can address each one, especially if we're up to 1,900 complaints.
And I would like to clarify that it's not common practice now for us to do an investigation and an inspection on every complaint.
Thank you.
Kathy?
I've been looking through our packet. Where in our materials today did we get the budget, where we have the full budget, the income expenditures, not just this, but the
So
longer, more detailed?
Agenda item 9, the expenditure report should be in there as well.
Okay, I'm not seeing it in what I have.
Rob, can you pull it up, please?
Well, I don't see it either. It's not an agenda item 9.
I don't see what we used to get. Is it because we're still not being able to,
It's not the fund analysis she's
the
asking for.
full expenditure
She's asking
report,
the
which has all
expenditure
those line
report,
items
the
that we used to
Just the
get,
regular budget,
the budget,
our P&Ls.
that we
What's
used to get a
after that?
longer, more detailed.
You want the expenditure. Is the expenditure report in there too?
And Kathy, you're talking about the one that had how much we spend on printing, how much we
Yeah,
spend
it
on
goes all the
travel.
way
Yeah.
through all the detailed
I
line
don't see
items
that
that
either.
we used to get, and, sort of the budgeted and the actuals.
Okay, so from my knowledge, I don't believe we were asked to provide that this time. However, if we were, because we are just in the new fiscal year, we have a budget for VetMed. We are still in the process of making some of those adjustments to your current budget with employee comp adjustments and retirement. So that will change, and we only have 1 month of expenditures right now that we can pull from. So we will definitely work on one of those in the next month or so, and then we can get that out for your next board meeting.
Okay,
So I know
typically,
that
we've
we-
gotten at every board meeting something, so that it makes sense about the fiscal year, but I just want to make sure we continue that
This
practice.
time, if we were to provide a projection, it would be, this is your budget, and we would probably be projecting you to expend your full budget at this time.
Any other comments? Bonnie, and then you.
Bonnie Lutz, I'm probably shooting myself in the foot here, but as far as the DAG costs, it's been my experience that the more experience, what the DAG is supposed to do is be your lawyer. So essentially what they're supposed to do is they're supposed to get what you send them, evaluate it, and then put together what they think, the case that they can prove, and put that into the accusation. Some of the more experienced DAGs do that. Some of the younger ones do it. Some of the offices are way overburdened at the DAG's offices, so they don't have time to do it, and some of them don't have the interest in doing it, so it's all over the board. But what that results in is an accusation with what we used to call in civil law, throw everything up against the wall and see what sticks. And that's not an efficient way of doing things. In civil litigation, it costs a lot of money because it ends up with a plaintiff filing a complaint that has a lot of stuff in it that they're never going to be able to prove, that then they have to go through discovery and do all that. Well, we end up having to do the same thing with a lot of these accusations that come from the DAGs. In other words, they're taking everything you give them, and you're not lawyers, so they're not evaluating the stuff, and they're putting together these, 15 and 20 cause for discipline accusations, of which I look at and I'm like, okay, you can prove something, you've got something, but you're not going to be able to prove all 20 of these. So then we go through this process of discovery and meet and confers and yada, yada, and we file our mitigation package. And, with the hopes of getting it cut down to something reasonable that we can either settle or go to the hearing on. But that costs you guys money. I mean, if you're just sending everything in your file to the DAG, assuming that they're going to make a reasonable determination of what will stick, that's not going to happen all the time. And as far as these paralegal fees, I mean, I know I'm on public television, basically, and everybody can hear me, but, the stuff I see coming from the paralegals is really not very good work. So in a lot of cases, those accusations are being amended 2, 3, and 4 times, which again is costing you money. So, I mean, I don't know what the answer is, except to suggest that, if you, and I know you're spending a lot of time, and I know you're overwhelmed, so don't get me wrong, but if there was more time spent up front, if you could get the people in your office to spend more time up front clarifying what things can really stick, what do you really have evidence for? And remember that at these hearings, the level of evidence is clear and convincing evidence to a reasonable certainty. That's what I call about 97%. So that's a high level of proof that you have to prove at that hearing to get that cause for discipline proven. So if you really are just like annoyed with the vet because he did something, or if it's a numbers game and you're throwing in an accusation, that a cause for discipline that has to do with a complaint you received that you really don't think has any legs, but you've got it sitting in-house, so you're just going to throw it in with the rest of the accusation, that numbers game never works, because, we're going to go after the big serious stuff that you actually filed the accusation for, but this other little piddly stuff you might not even be able to prove. But the DAG is costing you money for all of that. So, if you can do that, if you could tighten it up, I think there's a lot you can do, and really, over the years, and things haven't gotten worse since Jessica's been here. They've gotten better. So, I'm talking about before Jessica. But over the years, we got to see more and more of this, throw everything up against the wall and see what sticks. And again, that's costing you guys a lot of money.
So, a few things. Thank you. There's a lot of stuff I wholeheartedly agree with. My staff is, and I think we've reported the last few board meetings, they are doing a lot more upfront than they were doing in the past in an effort to streamline the process and to save AG costs. I can't speak for the quality of accusations and products from the AG's office. I can tell you that is something that we are painfully aware of now, and we are working our best to address it. I am very hopeful with our new DAG liaison. She's being very hands-on and fixing a lot of these issues that we've already identified, in addition to withdrawing some of the cases that were previously either filed or in the queue to be filed, because we do not, our current staff and management and myself do not believe in throwing everything at the wall to see what sticks. We believe in protecting consumers at the lowest level possible. And we don't file accusations if veterinarians annoy us. So we are definitely aware of this issue, and we are doing everything we can to decrease costs and streamline the process with the AG's office and our staff.
So the question, though, is there's no way to anticipate or predict if we are going to have any cost savings in the next year. That's a bummer. Yes.
It actually might not. I would actually, while we're doing these steps now, there's 1,900 pending cases. And there's a lot that are pending at the AG's office that we are evaluating. But we also, as we move through these cases, the AG costs might increase because we're closing more cases and pushing more cases forward.
Jennifer.
So I do realize that we are in kind of crisis mode. We need to do something now. What I think has been pretty clear is that there are several inefficiencies in the entire process.
Yeah.
I've heard a couple of ideas mentioned today that I like, reviewing the policies to try to find some more effective ways of doing things. A sliding scale for premises permit to me seems to make sense. As far as I don't know the policies, but with the DAG, if we could outsource or contract, I don't know if that's a possibility. I was in a situation once where there were, exorbitant fees from human resources, so we became a standalone agency with our own internal. We're not doing that, but there are a lot of things we could do. I just feel like raising the fees to caps on everything is just putting a Band-Aid on it when there are so many inefficiencies in the process itself. I don't know how to address that when we're in crisis mode. But it seems like there are several things that do need to be evaluated.
I mean, I agree. I mean, but I really don't see any way around not raising the fees right now while still aggressively looking at ways to reduce costs, because we're right in the middle of it. If we knew this was coming 5 years down the road, then getting, it would be, I would say, to DCA, finance, and to some of the other powers that be, that would be a great thing for somebody to create a best practices for case management for all the boards to see how, every board must have similar situations. Jessica and her team have made a lot of changes in our processing, but obviously the goal here is public protection, but we also need to do it as efficiently and cost effectively as possible for both the staff, wear and tear on the staff, as well as the budget. But I just don't know how we need a quick fix, unfortunately, it seems like now. But it is a Band-Aid, there's no question. But it means that this board has to be committed to, and DCA has to be committed to working with us to find efficiencies going forward, because we can't keep doing this the way we're doing it. And especially, all boards must have a high level of complaints. And the litigation costs, Bonnie said, are going up and up and up, and on every level. So, but we've just got to, we can't, I think it would be worthwhile to see if there are other board processes that might work better for us. I think Jessica and her team are already looking at all that, but anyway. It would be nice to get a little bit more statewide guidance on this to our individual boards. It's just what I'm throwing out there into the web consciousness.
Okay, Dr. Nunez.
And not to dismiss any of the issues that were raised to reduced costs, but will you entertain a motion to accept the original proposal of increasing all the fees?
From you, of course.
So moved.
Do I have a second?
I'll second.
We have a second. Discussion from the board, further discussion? Kathy?
Do we want to entertain the possibility of increasing all the fees, but making the RVT increase a time certain? Or, I'm asking you because that's maybe not a friendly
I hesitate to accept that,
Okay.
because I don't know if I have assurance that we will get that legislation passed through to increase the fees,
Oh, to increase the caps to begin with?
to increase the caps. So that's why I'm hesitant to accept that,
Okay, I got it, thank you.
not to be unfriendly.
No, you're right.
Tara?
Because this is a regulatory proposal, I've got the really long 45-day notice motion language when you're ready.
Do you have the emergency rulemaking language?
I've got 5-day emergency rulemaking language.
Okay, I think we have to do emergency rulemaking and then initiate the normal rulemaking. But it might be the same motion. I just know the last time that the board had to do this, in 2017, there was a clarification that the board did both motions, the emergency rulemaking process and the regular rulemaking process.
Rob, can you pull up the meeting minutes from I think it's December 2017?
And can I clarify, Mark, your motion was to, Dr. Nunez, your motion for clarification was to increase in the original proposal, so increase everything to 350?
My other proposal was to possibly have a bake sale with cannabis.
I added the cannabis part.
We should just resell the Panera cookies. Those are delicious.
Can I ask a question while they're looking at that? So if we don't have any stipulations about the RVT fees in 2 years, going back to the old levels or anything, we still have the ability to change those, so it's not, yeah, so okay.
And we will.
In fact, we don't have to.
Yeah, that's true.
I don't think we have to even raise the cap on the RVTs. We can raise the cap on the other licenses.
I think
But
that's
I will say it's very frustrating to be in a situation where the licensee, I understand the philosophy behind this, that the licensees are the ones that are self-regulating themselves, the state level. But then to not have any control on your expenses is really, frustrating to be able to, as a licensee, it's, you feel like that's frustrating. I guess I did some
Well,
private comments.
I know that it is frustrating, I'm sure, from a license, but you have to think about the government as a whole and the state laws and everything else, and we're one part of a big, huge budgetary system.
Yeah. Okay.
Okay, so the motion would be to initiate an emergency rulemaking and the general rulemaking in order to adopt the proposed regulatory changes, designate to the executive officer to take all steps necessary to complete the emergency and general rulemaking process, authorize the executive officer to make any technical or non-substantive changes to the rulemaking packages, notice the proposed text for a 45-day comment period, and if no adverse comments are received during the 45-day comment period and no hearing is requested, adopt the proposed regulatory changes with modifications, if any.
Okay, is that understood? So we have a motion and a second. Any more comments from the board? Comments from the public?
Cindy Savely, RVT. I just want to go on record to say that if you do raise the RVT fees, that new graduates will not be able to register to take the exam or the national, or existing RVTs that have been working for many years will not be able to afford that renewal. I just feel like I need to go on record to say that. And I'm talking about approximately 100 RVTs that I know in the local Sacramento area, as well as students going through a local RVT program. That's what I'm basing that comment on. Okay, thanks.
Thank you. Any other public comment?
I would agree with those comments.
I would also agree, and I'd say that you run the risk of actually destroying the RVT profession.
Call for the vote.
Ms. Bowler,
A very reluctant yes.
Dr. Bradbury,
Can I abstain?
you can. Ms. Laredo,
No.
Dr. Nunez,
Yes.
Ms. Prado,
No.
Dr. Waterhouse,
Yes.
Dr. Noland.
Yes.
We have 4 yeses, 2 nos, and 1 abstention. Motion carries.
Could I make a motion that, I don't even know if it's in order, but that once, that we revisit the RVT licensing costs at a time certain when we can't, when the budget allows this? Is that even possible to put us on the record as saying?
I don't think you need any kind of motion. I can tell you that I'm very committed to finding efficiencies and decreasing fees whenever possible. I can tell you that when I was at Board of Optometry, we were very close to being able to actually reduce fees, which is unheard of. And it has been a goal of mine. So I am committed to finding every single efficiency possible and being able to decrease fees wherever possible.
Is there any time, once we make a change in fees, fees, does that have to be in place for a certain period of time? Or can you make a change, in 6 months to reduce them? I'm just wondering, I can't remember, there was that bill, Pat.
You're talking about Assembly BNP's bill that?
Yeah,
we
maybe,
go through?
but I was just thinking, are we limited or restricted
No.
into the time we could consider lowering fees?
No, the board, it would just be another rulemaking packet to lower fees.
Oh, yeah, you have to
So-
go through that process.
Or we can do legislation to potentially set a lower floor. And, there's other ways that we can do it. There's no time limit on it, so as soon as we're able to project it, we can look at lowering.
Okay, thank you.
And I would also hope that the budgeting office takes note with how painful it is for us to just randomly increase fees. It's not an easy thing to do.
It's not
I know
randomly
it's-
either.
I know it's not your fault, but
When the ink is barely dry on the last increase we implemented.
Pardon?
When the ink is barely dry on the last increase we implemented.
That's true.
I may be wrong, but I think it was a long period of time between that increase and the one before that. And I think we might have made a mistake in the way we did that one. Okay, moving along.
Thank you very much for coming and coming
Yes, thank you.
twice.
Thank you very much for doing the extra figures. We're moving on to item number 7. Review, discussion, and possible action regarding state and federal laws related to pharmaceutical compounding.
Dick Sullivan again. MDC, although this predates this a little bit, the report in front of you is pretty complete. It's not me, is it? I just wanted to add that Dr. Grant Miller, Cheryl, and I attended the most recent Board of Pharmacy Compounding Subcommittee meeting a couple of weeks ago and expressed our concern about their proposed changes in their regulations, which you'll see, the pages aren't numbered, but on the next page. We found out about these changes like 3 days before their meeting, even though Tara and Jessica and I had a meeting with the Board of Pharmacy a couple of weeks before that, and this didn't come up at all. The three of us did express our concerns, not only about the changes that they're proposing, which includes us having to send medical records to the pharmacist when we are requesting a compounded sterile preparation. And if we if we want it in advance, we have to have a contract with the pharmacy, and that contract in which we would then have to document to the pharmacist if we request more of that same product. We have to document how we used it and if it got outdated and justify it in that fashion. So Grant was very articulate in his expression of concern over authority to require this, and we also expressed our concern as to how this hadn't come before our board and worked together. So we definitely are going to be following this closely. I see their October meeting has been canceled. Their November meeting is November 14th, and we will be attending, and at least I'll be attending. I'm hopefully others will too. On the next page, Grant came up with this. It's from USP, US Pharmacopoeia. On the second page, there's an interesting paragraph on how it applies to veterinary practitioners. And because, as you notice in my notes, the Veterinary Medical Board, CVMA, along with AVMA, has petitioned the U.S. Pharmacopoeia to reconsider our concerns in our ability to compound. And on here, it says, note to postpone these chapters and to maintain veterinary reference. And it states 795 and 797 do not state compendium requirements for animal drug compounding under federal law. Section 503A of the Federal Food, Drug, and Cosmetic Act, which makes 795 and 797 applicable to pharmacy compounding, applies only to pharmaceuticals for human use. So we're hoping that we can really use that type of comment from them, although we are proceeding with our appeal through AVMA. And at the present time, U.S. Pharmacopoeia has said that they have an indefinite suspension on putting forward their guidelines because of all of the number of stakeholders that are requesting review of different sections. And as I understand it, particularly that it has to do with beyond use state requirements. So unless there's questions, yes.
Yeah, can I, well, I noticed the next bullet point below the one that you read kind of seems to somewhat negate the first one. It says they could be, or they're intended to be relevant and useful. Are they talking about specific portions of 795 and 797?
As well, the part that is bothersome is that they state that it includes, in their guidelines, it includes veterinarians and veterinary facilities. However, the state law that has been passed specifically says pharmacies.
Okay.
So I think we have some room to work with. On the second paragraph, as I read it, is that I think that it states that it's best practices for both professions.
Yeah.
So again, I don't think that negates the first paragraph.
Okay. Thank you. Any other questions? Yes.
So where do we go from here?
I think we sit tight. There's no action, I don't think,
So,
required here.
do you think that
It's an update.
Jessica and Tara should kind of, I guess, research our legal standing and then approach the Board of Pharmacy through more informal means first?
We could do that. I think we also should list this on our sunset. I know that we had talked about during the teleconference having that on there, but then also having Dr. Sullivan present during that conversation, so we can mention it there, so the legislature is aware of it, and potentially mentioning the concerns that we have with the proposed regulations from Board of Pharmacy as well.
I will say that the committee was very receptive to our comments. Very receptive. I think Cheryl and Grant will agree with that. And this was approved by the subcommittee, but it does go to the total Board of Pharmacy. So the subcommittee is still meeting in November, so we'll follow up and see what's going on there. Staff didn't have much to say when we made our comments, but the president of the subcommittee did and was very encouraging with us to continue to work with U.S. Pharmacopoeia.
Would it be, would you be willing to come back in January and rediscuss it with us, or at least present what happens on the 14th?
Sure.
I'm sure some of us will be there as well, but it would be nice to put this back on the agenda.
Yeah, I think there's a road ahead of us, and I think we have to be at the table, or you know what happens.
Yeah.
Yeah.
Kathy?
When you presented to the committee, or the subcommittee, had they not considered some of these ramifications to veterinarians and to consumers and to everything else with the route they were looking to go to?
Yes, they did. As a matter of fact, as I understand it, U.S. Pharmacopoeia's recommendation is that all physicians, dentists, veterinarians do not do any dispensing to their clients. And so what Board of Pharmacy did was include this language to still allow us to dispense and for a limited period of time. I think it's 4 days. But we weren't actually in that discussion, so we need to be a part of that discussion as this moves forward.
Yeah, because there are a lot of ramifications for consumers.
Mark?
I know that when you take a step back globally and look at why Board of Pharmacy is revising all these drug compounding laws, is because there has been a lack of oversight previously to pharmacies that compound drugs, and they're just trying to tighten up on that. But when we're talking about veterinarian compounding, I've seen there's certain compounding that we do actually in our hospitals, and there's also compounding that we ask a pharmacy to do. And personally, when I write a prescription for a compounded medicine, I make it a point to only use a pharmacy that I know are familiar with veterinary medicine. And I know that there's a lot of pharmacies out there that want the business, but I won't give them the business because I don't think they are familiar with veterinary medicine as much. So is there any distinction with these exemptions that you're working on? Are they exemptions that apply so that the compounding done in the veterinary hospital can be continue? Or has there ever been a thought of only allowing certain pharmacies to compound veterinary drugs? Because right now, any pharmacy potentially could compound drugs for veterinary patients.
Any compounding pharmacy, correct. Our focus, and Grant and Cheryl, correct me if I'm wrong, our focus is strictly on the clinician's ability to compound, and what I keep referring to as simple compounding.
In their hospital?
In our hospital, as we have written in our proposed regulatory package that's going through OAL. So that's what our focus on. There are plenty of stakeholders at these meetings that are representing the veterinary compounding pharmacies. So there's two issues going on. We're focusing on the clinicians.
So there are pharmacies that are touted themselves as veterinary compounding pharmacies?
Yes, and even if they're outside of California, they have to be licensed with a California license to be compounding, being a veterinary compounding pharmacy that's legal.
So right now, Costco can't compound veterinary medicines, or
I have no idea, but I
wasn't aware that there's a specific veterinary compounding pharmacy.
Well, there's a license to compound. So then there are compounding pharmacies that specialize in veterinary compounding drugs. And then there's compounding pharmacies that do it for the human side, or in some crossover.
But there's no requirement, as long as you have a compounding license, you can compound a drug.
That's my understanding.
Does that need to be addressed or tightened up?
That's not my concern. My concern is our ability to continue compounding in our practices on a daily basis. We've got to have that.
I agree. Yeah.
And dispense.
I agree.
And that's
And
my,
dispense.
and to me, that's our focus. The compounding pharmacies have tremendous reserves, much more reserves than we do, resources, I should say. And they are represented on these stakeholder complaints to U.S. Pharmacopeia. I think it's kind of unheard of U.S. Pharmacopeia delaying the release of these documents at this point indefinitely because of the complaints, of the appeals.
Sure.
So the meeting that Dick and I and Grant went to that meeting was specifically about sterile compounding. And so in our field, that mainly affects ophthalmic. I don't know any veterinarians that are dispensing injectable meds. So ophthalmics. So that does affect us, like I use compounded tacrolimus that I dispense. And so it does affect us. And of course, I think the veterinary ophthalmologists are always making up stuff that they use. And I pointed out to the pharmacy board that, so if we can't dispense that, and then it may take 3 or 4 or more days at an emergency hospital, a 24-hour hospital. A client may have to send their dog or their cat to this 24-hour hospital just to have drops put in their eyes at, $200 to $300 a day, until they can actually get medication from the compounding pharmacy. And at that meeting, they were talking about the compounding pharmacy. It might take 14 days to get that medication because of the extra hoops they were making them jump through. So, yeah.
Yeah, and but we also use sterile compounding products in our practices that this would also affect in hospital use, so.
So are they trying to tell us that those things are used in hospital and they still have control over that?
If it's a sterile product, it has to be used within 4 hours, or you have to
Yeah.
remove it.
Kind of.
Kind of.
So, Grant Miller, CVMA. So we're having two conversations here. One conversation is what Mark was bringing up about our statutory authority to compound medications ourselves. So you, Dr. Bradbury, would take two things in your practice and you'd mix it together. You are compounding. We have statutory authority to do that because we, together, this board, secured that for us in law. And the regulatory package, which tells us how to do that, is currently in the process somewhere. That's not what this is about. And this is not about USP either. They happen to be using USP as a vehicle to institute several changes in their regulations. Why is that? Because AB 973 passed, which says that anything that USP says is now going to be state law. For pharmacies, thank you. Not for veterinarians. So USP has said, well, look, we believe that the parts about veterinarians are important because if they're compounding, we want to give them best practices because USP is not a regulatory body. They're just an association. And so they're saying, look, if you want our opinion on how to do compounding, here it is. And we think that the part about veterinarians is appropriate, but this isn't intended to be a minimum standards. These apply to pharmaceuticals, pharmacies, and if you want our opinion on vets, go for it. This regulation that you have in front of you from the Board of Pharmacy has nothing to do with aligning with USP. This has to do with the fact that they want to stop compounders from manufacturing drugs. So when you manufacture drugs, you go through something called a good manufacturing practice or a GMP. That is a very, very high standard. And FDA-approved drugs have to go through that. Compounders don't have to go through that. So here's the rub. When I call up a compounding pharmacy, or when Dr. Nolan calls up a compounding pharmacy and says, I need 20 tubes of tacrolimus, a compound, by the nature of what it is something that's custom made for an individual patient by order of a doctor. If you have 20 tubes of tacrolimus and you're giving it out to 20 patients, you're not custom making it per patient, right? But on the flip side of that, we know as veterinarians that there are drugs that are not FDA approved that we can only obtain through compounders. There's no other way. Tacrolimus is one of them. So is apomorphine. And so we are stuck in this situation of needing to provide a continuity of care for our patients, but being told by the Board of Pharmacy that there will be a minimum of a 14-day gap. So here it goes. Dr. Bradbury has a patient. The patient has a autoimmune fungal problem in the eye. The only way you can treat that is with a sterile compounded ophthalmic. What this is saying is that you are allowed to possess that in your hospital only pursuant to a contract.
Right.
And also, you must keep extensive records, which you now have to give to the Board of Pharmacy for their audit.
Right.
That's a new record-keeping requirement. What it also says is that under no circumstances can you give that medication to your client to take home. So here's the animal with the medical condition that needs to be treated 4 to 6 times daily. You can treat it in-house to a very limited degree, and once the person goes home, their solution is that you write a prescription to a compounding pharmacy, and that pharmacy will then fill the prescription.
14 days.
Well, in order to compound a sterile compound, it takes a minimum of 14 days. I would contend that in that 14 days' time, the animal's going to lose both of its eyes. So what they have done here is they have now created a gap in our ability to treat our patients, and they are now going to intensify animal suffering and harm, and they're going to harm consumers.
Yeah.
And that is where this board, I think, has a real opportunity to tell them, this isn't about USP, this isn't about what we as veterinarians are going to do with compounding, this is about you guys creating a regulation that now overrides our Practice Act.
Yeah, and is there any precedent for that, to have like some other board basically telling another board how they're going to be practicing medicine?
Off the top of my head, I don't know of any in particular, but it's possible to the extent that the practices overlap. And, you know, if we're talking about pharmacies, they deal with drugs, and if you guys are compounding drugs, I mean, it's possible there's overlap, but I think in this scenario, not so much, because they've got their statute, we have ours. So it is a bit curious with this regulation that they're proposing.
So, and to build on that, there are instances in which licensees are subject to dual oversight, but they're also licensed with 2 boards. And we have run into, I would say, turbulence before with that. For instance, the California Horse Racing Board, which licenses veterinarians to work on the track, has in the past written regulations which have interrupted the Practice Act. And luckily, those boards came together to find a solution to those issues. In this case, we are not licensed with the Board of Pharmacy, and so it is questionable whether or not they have the authority to request record-keeping requirements and to also request that we report to them. And I think that that is also another issue that this board should be bringing before them.
Would you suggest we should be bringing it before them in a formal letter, or would you suggest we continue our discussions as we have?
Well, I think that Jessica outlined pretty appropriately what the next actions would be, and I think that that's appropriate. As the subcommittee had stated to Dick and Cheryl and I, this is just the beginning of a process. They were very grateful that we were there, and just like anything else, they have to go through public comment. They have to receive public comment. I will say that in my experience, I find that the comments provided by other regulatory boards are valued sometimes more greatly than comments brought by other individuals. So I think that it's valuable that you're there, but I think that Jessica has a good plan laid out according to how the regulatory process works.
Thanks. Kathy?
Can I just ask a kind of a weird question. In human medicine, if a doctor prescribes compounded eye ointment and it has to go to a pharmacy, wouldn't there be a 14-day delay as well? Or I'm still a little confused, as that delay would apply to humans?
I think that's where the contract's going.
That's a really, really good question. And so there's two things that I would like to answer that with. The first one is that the pharmacies can have contracts to prepare certain items in advance to be ready in a reasonable quantity. And it's very hard to explain how this works, but at any given time, there is going to be a pharmacy that is bringing a sterile product to the end of its sterility testing, meaning that that product will be ready to be dispensed at any given time. The hope is that the number of pharmacies that are creating drugs are exceeding the need for the drugs. And so at any given time, a person can take their prescription to a pharmacy and say, well, I need this. Oh, you don't have it? Okay, I'll go to the one next door. When the Board of Pharmacy passed their last compounding regulatory package in 2016, the few veterinary compounding pharmacies that provided drugs dropped approximately 33% of their sterile product lines in California. So they said, it is no longer profitable for us to make these drugs and bring them to California because the regulatory requirements at that time were so excessive that they found it to be monetarily unwise. So we are in a different ballpark because there are very few pharmacies that actually do veterinary compounding. Within those pharmacies, there are very few that do sterile compounds, and within those, there are very few that will ship to California. So we don't have the same luxury of having, I think they have 76,000 licensees, 76,000 pharmacists in the state of California. We don't have that many doing veterinary work, and so there is a huge gap in care potentially here. Well, it will be. It's not potential. It will be. There will be a gap in care because we can't send home these medications with our clients.
What about out-of-state pharmacies? Can we utilize them, like Roadrunner, or?
Sure. So an out-of-state pharmacy has to have a satellite license. So essentially, there's no such thing. They are licensed by the California Board of Pharmacy, in which
So it would
case
still
they
apply to
are
them?
held to the minimum standards of the Practice Act. They won't be granted a license if they cannot adhere to the minimum facility standards of compounding.
Okay.
Right, and then I'd like to just add, there's another caveat. There's a classification of license called 503B licensure, which means that you're a compounding pharmacist, but you're essentially doing manufacturing. It's halfway between FDA good manufacturing practices and compounding practices. It's halfway in between, so you're allowed to create larger amounts and send them in. To date, there are 0 503B approved veterinary compounders in the state of California. We have none that are available to us. Even if they were available, if this regulation passes, we couldn't send home medications to our clients. So it wouldn't matter how many you had. You're not allowed to send them home.
So I think there's a real core problem in all of this.
This is
and
Valerie Fennismaker. Sorry, you need to say your name.
Oh, Valerie Fenstermaker, CPMA. The real core problem really is the Board of Pharmacy's authority, and it goes way back to when they first took, and it was stated that they had jurisdiction over veterinary drugs way back in the early 2000s, and the result of that was veterinarians had to, at that time, offer a written prescription, and at that time, our understanding was that they had authority over veterinary drugs. And moving forward, we've had a lot of problems over the years with that. And I'm not sure where their authority begins and ends with this particular compounding pharmacy issue that happened in this meeting. For us, it seemed like they went way beyond their authority. And the problem really is, and it's the same with the USP guidelines, they're not including veterinarians in the discussion. The USP guidelines, one of the things that we've asked for in the AVMA is to form an expert panel of veterinarians, not pharmacists, and also to have a separate veterinary chapter on compounding for the USP guidelines. The Board of Pharmacy, with what they've done, they didn't include you guys. You weren't part of the discussion, and they're pharmacists. So if they're going to oversee veterinary drugs, there needs to be some kind of cooperative relationship with the Veterinary Medical Board if they're going to be even looking at these decisions. In my opinion, they're pharmacists. So they don't know how veterinary practices operate, and they're not talking to veterinarians. So I think there needs to be either some take back by the Veterinary Medical Board of oversight of what happens in a veterinary practice, if indeed the Board of Pharmacy has that type of authority, to figure out what authority they do have, and if nothing else, to demand that you're part of these conversations, because we found out about this meeting just a few days before, and you found out about it just a few days before. And for us, that's one thing. For you, I find that totally unacceptable that as a board, you're not being included in these conversations. So I think there's some real core problems in what's going on, and decisions like these are being talked about in meetings and nobody even knows about it. So that's all I have.
So why isn't the EO of the Board of Pharmacy talking more to REO?
I can't respond for the interim or the acting EO at Board of Pharmacy. I do know that she reached out to us and wanted to have a meeting to find out more about compounding. That's the meeting that Dr. Sullivan, Dr. Waterhouse, and I attended. The specific regulations were not brought up, nor was the meeting that they were having.
Interesting.
I can't tell you why.
Well, it doesn't sound like it's acceptable
No.
that they are not including us in the conversation. And if we don't know why, then can we talk to the DCA about the Board of Pharmacy working better with us?
Yes. And Board of Pharmacy again.
Dr. Bradbury.
Yeah, I guess that was my question. We keep saying this is unacceptable, and there's asserting authority that they don't have, and we should be working with them. But what real recourse do we have if they aren't playing nice or they don't want to work with us? So I guess I just want to understand where we would go with that if they just aren't wanting to work with us.
So, one of the things we've discussed is including it in the sunset report. I do know that under Board of Pharmacy law, 4170 lists all the boards who can prescribe medications. And that's the one that lists us and says that our board is specifically charged with enforcing the pharmacy chapter as it relates to our licensees. And I think that needs to be looked at to see if maybe that needs to be made even more clear. But I think 4170B says that we have the authority and we are the ones charged with enforcing that statute as it relates to our veterinarians.
Okay, but then they write this out, and then what? So we just don't enforce it, but then they're enforcing it on the farm, we still can't get a pharmacist to prescribe something because we're not complying to their rules?
I think that we should still continue to reach out to Board of Pharmacy and work with them. I think that we can mention it in our sunset report and our specific concerns with the proposed regulations. I think that us continuing the conversations and inserting ourselves into the conversations, I think is beneficial. I do know that when we were meeting with the interim EO, she did tell us that she would let us know when the 45-day comment period happens. So there's that. And we can provide that comment, which we will be. So I think that we continue to do all of the above and try to figure out the best solution for consumers and animals.
Dick.
Just to give them maybe some leeway here, when we were writing the regulations for our ability to do in-house compounding, we met with them 3 different times. We had very good meetings with them. They're going through a fairly large transition. They're getting that, the executive officer at the time has retired, and they've just moved to a new building, so there's a lot going on. So I will definitely give them the credit, benefit of the doubt. But, the key is we have to keep working with them.
So, Mark?
Would it be helpful for Dick and Grant to go to a Board of Pharmacy meeting, and under that agenda item, items not on the agenda, to bring up this issue? Because sometimes I don't know whether or not the board, and perhaps the staff at the Board of Pharmacy knows what's going on, because there may be a disconnect between the actual board and what the pharmacy staff is doing. Maybe their board is not aware of all these issues.
They are now. The subcommittee was very responsive to our comments.
When you talk about the subcommittee, is that staff or
That's
is that?
board members.
Board members.
3 board members.
Okay.
And they were very responsive to us. They gave us plenty of time that we had a 3-minute limit, and Grant pushed that envelope pretty extensively. And we're committed, all stakeholders here in this room are committed to attending every one of their meetings. So I wouldn't be able to attend their October meeting, but I just saw it was canceled, but definitely have their November meeting on my list.
Do you spend any time at your practice at all anymore?
That's what my partner wonders.
Thank you very much, Dr. Sullivan. Oh, yes.
And I just wanted to kind of reiterate what something Jessica said. I really do think it's important in the sunset review process to sort of put our cards on the alert everyone to this, because this is going to be an ongoing process for a while, and that hearing is in March or whatever. But the fact that we can in that process get out a few of our concerns about this potential regulation as well, I think, and that alerts legislators and other stakeholders.
And again, I'm super happy that the new head of the DCA has a medical background. Super happy.
Okay, any other comments from the public of the board? We're going to take a quick break, maybe 10 minutes, and we'll be back at 2:50.